Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How, does the FBI find people? And people is misspelled P-E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
What more do you need to see?
All right, I think I'm ready. Good morning. Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Good Monday morning. Brand new week ahead of us. And boy, what a week it is. I'm telling you, it's going to be a crazy one. It's going to be crazy. People have already gone off their rockers. Let me just say, they've gone off their rockers. You don't even have to go to Twitter or X to realize that, but that's a good place to look and see it. See it live and in person. Let's see. I've got stickers. I've got remotes. I think we're good. All right. Good morning. Good morning. Good morning. What happened to the rhymes? It has been a weekend and a half. If you look carefully at my fingers, you'll see that there is paint on them. I tried to get as much of it off as I could. I got up bright and early this morning, and in between writing the lyrics for my new album. And working on the bathroom, I'm way behind. The bathroom is not done. It was supposed to be done today, which means I have to work all night as well. That's the only possible solution. So I have to work all night as well. So yeah, that's going to be fun. But I did get a first layer of paint on, the primer, the sealant. We use a Latex Kills sealant on there to make sure, because it is a high humidity room, so we have to do the proper sealing on it. But it's all down. I've got the whole thing primed. My daughter helped me. She did a great job. It's ready to go. It's actually dry and ready for the next coat. But so tonight, second coat of paint.
More experience.
Second coat of paint. Flooring goes in. As soon as the flooring's in, I can start putting the appliances in. We went out to Lowe's over the weekend and bought everything they had in the plumbing department for fixtures. Still need the grand finale of bathroom features ordered, but we'll get there. We'll get there. So we have the base toilet, just the one chair.
The zombie apocalypse
chair height
may be upon
elongated.
us.
For those that are curious, chair height elongated toilet, and the shower is ready to go. The pedestal sink that matches the same design of the shower. We've got that. I don't have the mirror yet. Need to do that, but we're ready to go. Anyway, we have a couple things we need to do before court starts, which is any minute now. Just 1 second. Yeah, they're about to start. So we've got a few things. Are you inhaling the paint fumes? Yes. Why don't let those go to waste?
Somebody just sent me a video of roaches
here's what we need to
fighting. I don't know who won.
Good morning, Sophia Starlin. First in chat this morning, which means, Sophia, that you are kicking off the week as our leader of internet owners. Today is your day. This is your moment to shine. The internet is all yours. Congratulations. It's a punishment, actually. But we like to wrap it up with a bow and tell you it's a prize, just so you work harder at it. But please keep the internet up and running for the rest of us. We'll all be happy. Thank you so much. If you want to commemorate this offense, or this win, excuse me, you can go over to the shopping page on the YouTube channel, and for the low fee fine of 50 cents, you can download your own fill-in-the-blank digital copy of this in certificate form. All right, lots of fun going on. Court is great. I had so much fun making that song the other day. I had so much fun. I have had everybody I've been sent all sorts of remixes and samples, and everyone from Matthew Harris Law mixing it up for me on request, all the way through.
Bring the jury,
Courtney. Yeah, I've got all these different takes, and lyrics have been submitted. I've got so much music material now that I pretty much can launch my career. So, so big deal it is. Had the rap on throughout the weekend, says Evie. My partner loves your rap name, Ari. I've fine tuned it. Like even that version, I'm trying to mix it up and make it a little bit better. So it will rise up again. And maybe just maybe I might do a friendly challenge to LawTube in general for a rap contest, because clearly we need to see who is the who is the big deal. Let's see. So rhymes will be happening sometime in the future. Let's see. We have birthdays to do. We have birthdays before court starts. Where is camera 3? Oh, it's right there. Found it. Do I need that? Okay, I don't need that. I think we're good. I need to, don't let me forget set up for Chad Daybell. I need to get that going over on Top Mark as well. But let's properly celebrate those who are celebrating their birthdays. How about that? Let's see, it's my birthday. I'm half 100. Lisa says I'm half 100, halfway there. Wow, it's all uphill from here, Lisa. The easy years are behind you now. Now you got to get to work. You're an adult now. You just got to buckle down and get things done. Lisa, that's awesome. Can't wait to add you into the birthday song. Before we do birthdays, though, let me first say thank you, DSN, for gifting a membership first thing in the morning. Mel Poi, welcome to the gallery. Green Courthouse by your name, thank you. Tisha S, member for 6 months. Look at the stars. Look how they shine for you and everything they do. And they were all yellow. Squirrel. Rag for life. Yes, I love it. I love the profile picture. Waving the flag. It's great. It's great. I love you guys. You guys are so creative. It's amazing. All right. Big deal in the house. We're here. Birthday was yesterday. Suzanne will add you to the list. Does that work? Just how big is this front row? We have not yet found the limits of what we are capable of when it comes to the front row. I can tell you no one has a bigger front row than Big Deal. Yeah, is there too much of a good thing? Maybe so. Gally May, member for 12 months. Look at you a whole year. Love you all. Thank you very much, Gally May. Orange looks great on you. Thank you, thank you. And I love that profile picture. Is that a wave? You're looking at the sunset through the curl of a wave? Looks cool. Maybe it's a crocodile eye. I'm not sure, but it looks like a wave to me. Might have some Big Deal merch in the works. That is what we need right here. Let's see. Skylar Marique. Is it Marique? I know I spelled that. I said it wrong. Kinsley, Lisa, John, Renee, all celebrating their special day today. Is there anyone that we left off of that list? If you didn't just hear your name as I read them all together, please let me know. Ashley, thanks. Lisa, we got you on there. I think we're good. Brandy, are you in the house? I don't know. I think she might have been in the house at least briefly. Brandy's starting a big day today with her trial. She's been working towards that for quite a while, and I'm surprised that it happened, that we're there. But let's see. Kelly trial, when will the hearing begin? I'm not sure of the timing of the hearing. We're going to watch for it. But the Kelly trial is the prosecutor decides today. There's Brandy. Enjoy my last few minutes of peace. Brandy, we have a rap. I'm not sure if you've heard. I released my new single. I don't know. Can we play it? Can we do it? Can we get away with playing it once this morning? Is that all right? Let's see if I can find it here. Oh, man. I'm not sure which version it is. I've got like 7 versions, and some of them are good and some aren't. Okay, here we go. We're gonna play this one, Brandy, just for you. This is it's coming on camera 7, just audio. Okay. I think we're good. Ready, set, go.
Wake up in the morning wearing headphones. I'm running court into your brain like it's an end zone. My money's green like the pickles and you want some. Don't interrupt cause I don't want your lame objection. From leg t-shirts to murder, I think I've seen it all. From picking juries to when the gavel falls. The judge takes the bench and the bailiff yells, all rise and pay respect to the one and only go to true crime. Imitators they try but they just can't achieve. And when they fail they be like, ow, I stepped on a beat. Take the stand and the jury chooses not to believe, because there will never be another creator like me. Big deal in one corner and the count in another. We've got the judge reading chat while we talk to the lawyers. All our clips go viral, they're the good not to share. Came in late, check the thumbnails, you'll find it all there. They say I'm addicted to rhyme, but it's more than just time. And the mic is hot, the gavel drops, and I'll be talking about crime. And don't you worry about the sound, cause I'm keeping it real. Just like a pickle jar, but I'm one big deal. They say I'm addicted to rhyme, but it's more than just time. And the mic is hot, the gavel drops, and I'll be talking about crime. And don't you worry about the sound, cause I'm keeping it real. Just like a pickle jar, but I'm one big deal.
So, Brandy, yes, if you missed Friday, our trial is all about gangs, as we're actually jumping to that now. It's all about gangs, and we figured what do you do after learning all about gangs and songs and music and the drug life in general? And we said we have to, of course, make our own song. So I wrote the lyrics. Courtney Meek and a couple others helped in a big way, pointed me to some software that helps make this song. We've got a whole album coming up. I've been writing lyrics all weekend long, and I'm loving it. So anyway, that's where we are. We're about to start court. I thought you'd like that, Brandy. Good luck on your trial. Let me just say, Brandy, I love. Oh, I have to sing birthdays before anything happens. I love the way you're handling a very, very difficult trial with some strong feelings on both sides. So. Really excited for that. We'll be watching. Brandy's following if you don't know, Brandy is doing the Karen Reed trial. She has done tons of background. If you don't know what the Karen Reed trial is about, episode 1 of her podcast will get you all caught up. So excited for that, and can't wait to see how that goes. All right, we have to do quick birthday songs. Everyone warm up with me, and then we'll turn on the audio from this. Looks like defendants are there, but they're still trying to figure things out. Everyone's standing around. So warm up with me. This is the world's largest birthday celebration. Please join with me. La 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 la. Quick warm up. Dancers at the ready. No time to stretch. Don't pull a hammy. Here we go. We're singing to Skylar, Marique, Kinsley, Lisa, John, and Renee, and then we're starting court. Happy birthday to you. Happy birthday to you. Happy birthday, Skylar, Marique, Kinsley, Lisa, John, and Renee. Happy birthday to you. And happy 20K to Brandy in advance. I think it's going to happen today. Ashley, I think you're right. Montana, happy birthday to you as well. I apologize if there's anyone we missed. We have to bring in court. For all those that are celebrating their birthday today, whether it was yesterday, tomorrow, today, 2 days ago, if you're celebrating today, happy birthday. Thank you very much for celebrating with us. We realize there are a million places you could be and a million people you could be with, but you've chosen to be here with us, and that honor is not lost on me. Thank you. Hopefully we can make your day a little specialer. Make sure you head down to Denny's, get your pretty pancakes, and have a great day. Thank you all. Dancers, I'm sorry. I should have given you time to warm up. You did phenomenal, as usual, but I shouldn't put that sort of stress on you. Thank you so much. All right, now we're ready. I've been up since way dark 30, and I'm so tired. I drank all the Mountain Dew already over the weekend, so it looks like they're not even ready.
Great. All
right. We're ready. Good.
Let's get on the record. It is Monday, April 29th, a little after 9 o'clock. And this is day 6 of State versus Pritchett and Robinson. We have our prosecutors here. Ms. Mignot and Ms. Blake are here with Mr. Robinson, and Mr. Pritchett is here. Mr. Hiles, I'll start with the state. Anything we need to get on the record before we bring the one juror out who has something she needs to share, and then her 12 other colleagues.
Yes.
You're losing a
I would
juror?
like to go ahead and tender into evidence the certified conviction, as well as the original first offender sentence and revocation and entry of adjudication of guilt under 18 SC 158229 for State versus Max Pritchett, which was the 2015 incident, which resulted in the home invasion that resulted in the death of Jose Greer. The court has instructed that there be no mention of the death of Jose Greer in front of the jury. So I have redacted the what's been marked as State's Exhibit 37. To take away all mention of felony murder.
37 is?
37 is the redacted copy. 37A is the original certified copy.
But 37 would be the indictment, the plea, the sentence, the resentencing. It's the whole packet.
Both, yes.
Okay.
And yes, both 37 and 37A are presented as the indictment, the first offender sentence, and then the revocation and entry of adjudication of guilt.
Got it. 37 is redacted, 37A unredacted.
Correct.
And you are tendering both right now. 37A will be made part of the record, but will not be shared with the jury.
That's correct.
Okay. And those are certified copies?
Well,
the only ones that could be certified would be 37A.
Yes, 37A is certified copy from the clerk.
You can't have redacted certified.
Which has been completed in the defendants, or the exact copies minus the mention of felony murder.
I think it just shows a burglary.
That's it.
Okay. All right. Those are self-authenticating court documents if they're certified, which they are. Ms. Mignot, any objection to the admission of 37A? That's really what would be admitted. 37 is, they'll both be admitted, but 37A is the original evidence. Any objection to either?
And I believe 37 depicts certified convictions and revocations not pertaining to my client.
Both, correct. 37 and 37A, they're related documents. They're all Pritchett. 37A is the originals with nothing redacted. 37 is redacted. Your client's not even in the indictment. So he is nowhere on it. And before Mr. Hiles discusses any of that with the jury, I'll be giving a limiting instruction that anything and everything that comes in through Detective Velasquez relates, if it relates to anyone, it relates only to Mr. Pritchett.
Thank you, Your Honor. No objection to 37 or 37.
All right, Mr. Pritchett, any objection to states 37 or 37A?
What is the relevance? I know what is the relevance?
Well, I don't decide relevance, but if you're objecting on relevance, I will tell you that I've already ruled. We had a hearing a while back, and you were here. Ms. Williams represented you at that time on this 418 motion that the state filed, and they argued successfully, in my mind, under the state of the law, that evidence of the prior home invasion case ought to come in because it was their claim gang related. And even if it's not gang related, burglary and home invasion are crimes that come in under the rule of evidence 418 if there is a gang prosecution, because that is the type of offense covered by the Street Gang Terrorism and Prevention Act. So I've already ruled that it's admissible, it's probative as to potential connections to a gang. In theory, it would be the same gang. That's what the state would argue. But it's also probative, I found relevant, because the state is going to use it to attempt to explain why, in their mind, if you were involved with this home invasion, you elected to leave your phone at Voss Coleman's residence. It's kind of strange talking to you about this because I'm not making any findings at all. I don't know what the jury is going to decide, but the state's theory is, one, it connects you to gang activity. It comes in under 418 that way. Anyway, it has additional relevance in that it explains why you would think, hey, let's leave our phones, Tyrone and Max, at Voss's place and just use the girls' phones for the ladies' phones for the home invasion. So I want to be real clear. I'm not pinning any of that on you at all. That's what the state's arguing, but that's why I found that it was relevant. And these convictions are simply proof that conviction, and then it was a first offender finding, which is not a conviction. And then, as you know better than I, that first offender conviction was revoked, and a different judge entered a guilty conviction for burglary at that probation revocation. And all of that is just proof that you were involved with that first home invasion. So there's a whole lot of words. It's actually not that complicated, but you ask a fair question, and I wanted to give a thorough answer.
Yes, I would just object to the relevance and the fact that I wasn't present in that hearing when that motion was ruled upon or argued about, and just for the other side of why that was admitted, I would object to this speculation.
Okay. I will overrule, but I understand your objection as to relevance. I'll overrule the objection as to speculation. I don't think that one is as well placed as the relevance objection. And I want the record to be clear that while you may have chosen not to be present for the hearing, your then lawyer argued very effectively, opposed the state's motion. I ruled against her, not because she had a bad or weak or insufficient argument, but the law is very, very accommodating to the state in Georgia when it comes to admitting other acts evidence through Rule 418. So your objections are noted and preserved and overruled. Mr. Hiles, anything else from the state? Ms. Mignot, anything we should talk about before we start the jury process for today?
Just one quick one.
Sure.
So we know that there's one juror that has to bring something up today. It might be an availability issue. It might be somebody that talked to her. It might be, could be anything. You know, juror problems are the most bizarre problems we ever encounter, I think, in life. But we have one, I believe it's indicated that's a female juror that will be speaking to the judge and the attorneys and bringing something up here before court starts. This would be, if we lose this one, she would be our last alternate.
I hesitate to go near this can of worms, but I couldn't help but overhear wait, I didn't get the PowerPoint yet. Have you had an opportunity to look over the changes that I required Mr. Hiles to make, or that he volunteered in certain areas to make, to what we've been calling the Miller PowerPoint? And if you did have an opportunity, even though it may have been just now, are there any concerns? You've preserved all sorts of objections. And when Mr. Hiles tenders that as a demonstrative aid, all you'll need to do is say, I renew my objections. I'm just wondering if there are any new ones so that they don't cause us to have to send the jurors out when Investigator Miller takes the stand and Mr. Hiles tenders whatever exhibit number that's going to be.
Yes, Your Honor. I'm glad the court brought that to my attention.
I'm not, but I needed
to. It would have happened before the jury. And we had this in the back.
Yeah.
In efficiency, Mr. Hiles, we had a long discussion with the court that Mr. Hiles was going to send the redacted PowerPoint presentation, so I would have an opportunity to look over it. I think I remember saying, not at 7 a.m. on Monday morning. However, I didn't get it at all. And Mr. Hiles has replaced it, and I object to the one he replaced it with. And he also, instead of removing one, modified it. And that was not the agreement that we were going to modify it. When the court said 15 is out, 20 is out, 21 is out, and if you want to replace 20, you can replace it with something, and whatever you replace it with, you show it to Ms. Mignot, get her the PowerPoint presentation so she can address that. That did not happen. So I object to what he replaced it with, and I object to the modification of the one he kept in.
Okay. I'm going to add a little bit to the record you're making. I have the same recollection as you, that you and I were told that we would get the PowerPoint far, far in advance. I didn't get anything. So apparently it went to a different defense attorney and a different judge. I kept some pretty clear notes, so I'd love to see what we've got now. There were certain things that I directed needed to come out, not modify, but come out. It was really, I think, only slide 21, which had the gravestone of a rival gang founder or something that had been defaced. That needed to come out, but I may be misremembering. My notes say these other slides needed to come out. There's only going to be one hybrid slide, not two. I don't remember what slide 20 was, but I have there that it was coming out. But I'm going to turn to you, Mr. Hiles, and why don't you, because I don't have the new one, I can't look at it to say, yep, that complies with what we talked about.
I thought I was sent in court forwarded from Mr. Abate, like you would have done before we left. So if you want, I replaced the slide with the person holding the exotic, talking about exotic snake.
Oh, right. You were going to replace that with, we did discuss that, but what number is that one?
I'm not sure what number it is now.
Well, here, I have the old one. And so we're going to work through that. I'm pulling it up now. So slide 20. Okay, slide 20. I'm going to write reptiles. Slide 20, I had said needs to come out. There was one that just looks like you're in the jungle, and another, maybe some rebel in a country, and then a guy with two serious looking guns and a snake. And you said, you know what? I'd like to replace all those with a still from whichever of the two videos that that are coming in against Mr. Robinson. And what you represented was you were going to get a still from that. Is that what you did?
Well, yes, but it was a still that was posted through Instagram.
Okay.
So yes, I did.
Posted through Instagram by?
It was posted by Slim Santana, but it was taken off of Mr. Robinson's phone.
So it was found on his phone?
Screenshot.
On his phone?
Yes.
Okay. And what's that? Oh, something just came.
I don't, well, we can shorten to make it easier. I'll just take it out. I don't think it adds anything necessary, and that way there's no objection to preserve.
Okay. I see it. Yes. So it is now 19 in your revised one, and you're going to take 19 out. Okay. It looks like you took out 15. That was the second of the two hybrids. So now we just have hybrid vehicles. So that's consistent. On what is now 20 was 21, that's labeled tagging. You complied with the request, not the request, the direction to remove the gravestone. And so we've got the house that is marked up and the fence. And I understand Ms. Mignot has lodged objections to that. It's a different address, it's an abandoned house. I overruled those. So Ms. Mignot, any other slides? I think you had said there was some other new one. I'm not seeing other new ones in here. It doesn't mean there aren't. But tell me, using page numbers, to which you continue to, I'm sorry, not which you continue to, because you've preserved all your objections. If there are any new objections, now that we've addressed that, what in the new one is numbered 19 is coming out, and that is a different snake picture.
The only issue I had, Your Honor, is that number 21, I understood the court's instructions was that it was out, not that it was modified. The state was supposed to modify that.
You're talking about old 21 with the gravestone?
Yes.
Okay.
21. That was my understanding when the court said 21 is out.
LEB, thank you so much.
21 is out unless it's modified. So now we have 21 being modified. I would still object to 21 based on the court's ruling that 21 was out. I think we're teetering on trial by ambush when the court issues an instruction that something is out, that we should not interpret that to mean, as counsels of the court, doesn't mean it's out if I change it, if I modify it.
Okay.
So 21 is still an issue for me because I was under the impression that 21 was out. I did know that the court instructed that 20 would be replaced, and the court made that explicitly clear that 20 was going to be replaced with something else, and before I objected, I should wait and see what it was being replaced with.
Got it.
I know that issue's been resolved because Mr. Howes is saying he's removing it. But 21, I think in fairness, should also be out based on the court's ruling. Everything else is just the same general objection that I believe that this demonstrative is more prejudicial than probative as it pertains to the charges in this case, the facts of this case, and how this case went.
Got it. Understood. So I have a different recollection than you. The record will show whatever was discussed last week, but my clear recollection is that I directed Mr. Hiles to modify what was 21 and is now 20 to remove the gravestone, because it started with a question of whose gravestone is that? And if it was just a random citizen, it was definitely coming out. He explained it wasn't, but I still decided that picture should come out. And so I find that Mr. Hiles hasn't ambushed anyone, but has complied with my directive. If for some reason I'm misremembering, I do find that what is now slide 20 was 21 is appropriate and can be part of the demonstrative aid that this PowerPoint is. The question about the reptile slide, which used to be 20 and is now 19, is moot because Mr. Hiles is going to remove 19, which was a replacement, which was the offer he made when I said none of the reptile pictures in what was 20 were acceptable. I misunderstood him and thought he was going to insert a photo from one of the videos in which Mr. Robinson appears, but it doesn't matter because you're going to take 19 out anyway. So I don't need to say anything more about that. And otherwise, I find that you comply with my directions. So you've made your record, Ms. Mignot, and you can renew it when this is tendered simply by saying we renew our earlier objections, and I'll make a clear record of that. Mr. Pritchett, anything you want to add beyond what Ms. Mignot had to say about the revised PowerPoint?
No, I would like to adopt her objections to it being more prejudice than probative. Yeah, just like 19, the hand signs, like there's no photos of me ever throwing that hand sign up, or I just feel like things like that are gonna be prejudice.
Okay.
Or the extra things surrounding whatever was shown in the photos of me.
All right, got it. You've preserved those objections, and you previously adopted and added a few when we talked about this before. So all that is protected, and you've preserved those. I'm going to allow the presentation as it is, with a reminder to Mr. Hiles that I will be that annoying amusement park person moving the line along if we dilly-dally on slides that don't relate directly to this case for too long. And we'll see how that flows. Ms. Mignot, anything else on behalf of Mr. Robinson?
No, Your Honor, but I do have a separate matter that I'm going to need the court's assistance with. I do have an emergency situation.
Uh-oh, you need to step out?
No, I need the court's assistance with it.
Okay. Let me see what's going on with Mr. Pritchett, and then you and I can, you believe we can talk ex parte?
Yes, sir.
Okay, we'll do that. Mr. Pritchett, is there anything you want to discuss before we bring jurors in? Okay. All right, Ms. Mignot, let's take a quick second, and then let's bring juror 39 in.
So they're talking ex parte about something that doesn't affect their client. I think. We'll see. Not quite sure. My kids took apart the my broken drill, and it has amazing, like, strong magnets inside, but I still can't figure out what broke. The whole thing just smells like it's burning. All right. Apparently, Vicky thinks she wants to challenge us in a rap battle. Look forward to it. I will say I'm fine with the rapping and having the overinflated ego type content, but in my rapping, I don't want anyone to actually be offended. So I don't want anything in there that would actually offend somebody. I want it to be fun and lighthearted, even if we're poking a few jabs. But I've probably got 2 pages of lyrics for the next song that I'm sort of piecing together in my head. And it's going to be good. Monday morning messes. Yeah, they've got a few. This is just the start. Oh, the judge and the prosecutor are still talking it over. What is this? Usually they have one from each side in the discussion. But when this is over, we also get to so we've gathered all the people with ADHD from our channel. So every time we started, we had a squirrel moment. It could take months, says Vicky. Love it. Well, Mr. Upper Torso, I'll give you the lyrics because I don't. Believe it or not, I'm not good on the mic. So. Oh, there's going to be a rap rivalry, and there will probably be a sole victor who gets crowned with some sort of award. Oh, DA went to the back of the room, not in chambers. Okay, so the judge, I assume the judge is back. Still have the jury issue to sort out. One juror has a problem, needs to be brought up. Still don't know about the juror with the issue. Okay, all counsel is back. It's just for this trial, I think. If we were following Young Thug, then I think we'd just be a straight rap channel. I'm sort of torn. I should challenge Brandy. I'm sort of torn between doing a rap challenge and just like doing a tribute. I think a tribute would be more widely received. Hey, Chad. Karen Reed trial you're going to find live. If you want a lot of background analysis and an understanding to the underlying things that are happening in the case, Brandy Churchwell, I think, is one of your best options there. I know Emily D. Baker is also following the trial, but more as just like a juror, sort of coming in, with a clean slate approach. But they'll both be following that live. I don't know what the delay is. The attorneys talked to the judge briefly. I'm not sure if the judge returned. I haven't heard him talk since they came back. We're waiting for the juror issue to.
Hello. 1 second. Everything's good. That actually didn't come from the court. It came from opposing counsel, who didn't handle it well. Apparently, it's been reset a couple times because people are busy and life is complicated, but it will be reset because you are unavailable as vouched for by the judge, in front of whom you're appearing right now. So you bet.
She was ordered to appear somewhere else.
Just working through an issue. So you are juror 39. That's the way we're going to refer to you for this discussion. And Deputy Gordon mentioned there was something we needed to talk about.
Well, Your Honor, thank you so much for inviting me to discuss this. So it's a personal matter. On Wednesday, May the 1st, that's my putting ceremony for my master's degree.
Oh my gosh, you need to be there for that.
Yes.
Okay.
It starts at 9 a.m. So I was concerned if the trial does not end on Tuesday as we expect. So we need to just.
Could we all come? If the trial's still going and we pause, could we all watch you get hooded?
Yes.
Where does it happen?
GSU.
Okay. How long do you think that will go?
Well, I think maybe 2 or 3 hours. I'm not sure.
Okay. Know that you will be there. We'll figure out where we are. If we're not done and we need to pause and just start that afternoon, that's a once in a lifetime situation and would definitely qualify as one of those hardships that we had a chance to talk about. But Wednesday was far outside the window we were discussing. So don't worry about that anymore. You will be there for the hooding ceremony. Okay, thank you for flagging that.
So she's getting her master's degree. The hooding ceremony is Wednesday. She's like, Judge, I'd like to be there. I've sort of worked a long time in my life in this direction.
That is our alternate, so people know where she falls in the process. All right. Unless something changed in the last few minutes, I think I can bring the jurors in now. So seeing no one react otherwise, all right. Let me connect that. Hold on 1 sec. It's a lot of moving parts this morning.
I think it's funny that the judge
was actually on the bench. I don't know why she answered her phone. She's like, hello, what is it? It's like, I have Ms. Mignot hostage. Okay, thank you.
Miss Mignot, there's some other proceeding. Now, I don't know if somebody can research this. I've heard allegations of involvement of possibly.
We had a rookie setting up the Zoom today, so
even allegations that of charges against someone that might be acting as counsel in this one. I don't know if I understood that right, but Miss Mignot was supposed to be in another court right now that the judge basically had to call and say, look, I need her to have a hall pass because I sort of need her here right now.
What's on the screen? Is it like art? So it is art. It's like Michelangelo having sculpted something.
Their screensaver is what he's talking about.
It was done by someone else, so I will forward it in a moment.
That's what you want.
Find this here.
So I don't. Okay, I'm just saying. I've heard some rumors. I've heard some texts that.
I see. Yeah, I see it now.
You got the link?
Yes, we got an email from Ms. Hansberry.
Ms. Hansberry, yes, she is substituting for Ms. Nelson today. So you everyone got it?
We had it.
I just got it.
Okay, great. All right, let's bring those jurors in. They must miss us.
If you will bring the jury.
Let's see, Angela, you haven't answered me about the gig next week. I can book whatever date works for you between May 4th and May 12th. What gig? Oh, you're booking me for to headline your concert? Is that what you're saying?
Object.
I must have missed a text or something. Headline with the one song we have. It's going to be a short concert, Mandy.
Happy Monday, jurors. You look awfully perky for a Monday morning. This is our first Monday with this kind of relationship, because last Monday it was kind of anonymous. You were one of 51 or however many we had. So this is a different Monday. Hope you all had a good weekend doing something other than thinking about this case. I went to the Renaissance Festival with a couple of my kids.
Did a little LARPing.
One of the new foods there was, it's always on a stick. That's how they do things. And it was s'mores on a stick. And we're intrigued by that. It turns out it's golden grams with like melted marshmallow and chocolate on a stick. It tasted all right, but I was a little underwhelmed. Like that would be like actual s'more. But that was my way of taking a break from State versus Pritchett and Robinson. You all can be seated, but we're back. The state continues to have only 2 witnesses left. I asked Mr. Hiles this morning, any change in that? And he said, nope, 2 witnesses. So we will get through those witnesses. The state will rest, and then we'll see where that takes us. Mr. Hiles, call your next witness, please.
Call former detective Vincent Velasquez.
And as he is coming in, I need to share with you all that this witness is going to be presenting testimony that, if you credit it in any way, is relevant only to Mr. Pritchett, the accused. Whatever he shares with you should not be considered in any way as to Mr. Robinson. Morning, sir.
You swear affirm the testimony will reveal the truth, whole truth, nothing but true self. I do. Can you say this way name and record?
Vincent Velasquez, Velazquez.
Good morning, Detective Velasquez.
Morning, sir.
I direct your attention to what has already been admitted as State's Exhibit 2. Which wasn't here, please.
Atlanta 911 operator 6561. What's the address of your emergency?
1325. Someone's trying to get into my place.
1325 what?
898 Oak Street.
What's the address?
Oh, man.
898 Oak Street.
898 Oak Street?
Yes, Unit 13.
Is that 1 minute? 1 minute. Is that northwest or
They're trying
southwest?
to kick my door down.
Northwest or southwest?
Southwest.
And it's Unit 1325.
Yes.
Can you see the people?
Yeah, they're kicking it.
How many?
Looks like 2.
2 males?
Yeah.
What's your name?
Jose Greer.
Mr. Greer, what's the phone number you're calling me from?
678-314-1245.
678-314-1245. Can you tell, do you have any clothing description of either one of the males?
No, black. They look black. I'm on the 3rd floor. I might jump off the balcony.
And they coming through the front door?
Yeah, it's an apartment complex.
And you're on the balcony, you said?
3rd floor. Please send someone. They kicking the door in, ma'am. They just kicked it in.
Detective Velasquez, do you recognize that phone call?
I do.
I didn't recognize that phone call.
That's the 911 call from Mr. Jose Greer that I obtained during my investigation pertaining to a burglary that was occurring while he was in his house.
Okay.
They can't mention that he died in front of the
Where do
jury.
you work right now?
I own my own private security consulting firm. I'm retired.
Okay. Where were you working on December 8th of 2015?
Atlanta Police Department.
Okay. And when you worked at the, how many years did you spend at Atlanta Police Department?
22.
Okay. Were you ever part of the cold and complex case division?
I was.
Okay. Is that where you were assigned on December 8th of 2015?
Yes.
Did the 911 call that we just heard from Jose Greer, did that come to your desk as part of a complex case?
Yes, it did.
Okay. And what were the complexities of the evidence that required it to go to yourself?
So the date of this call, actually, I received the case the morning after, when I think the precinct detectives were handling the case. And then the fact that the victim jumped off the balcony was unusual, and there were some complexities to that case. They transferred it over to our unit and then assigned it to me. And also the extent of the victim's injuries.
Okay. Was the data in which you used to solve this particular case complex in itself?
Some of it was, yes.
Okay. So let me go back to the date that you were assigned this case. How were you able to start your investigation?
The first thing I did was I went back to the scene and spoke to the manager of the apartment complex. I believe her name was Kimberly Mitchell. From that conversation with her.
Hold on 1 second. There's an objection. Yes, sir.
He's reading off something.
Okay. Mr. Hiles, can you manage that, please?
So, Investigator Velasquez, if you need to refresh your recollection with your case file, you're welcome to do so.
Good objection.
At that time, but please don't read from it. And I would just ask that if you're not using it, you just close your file and set it to the side. So
okay.
Does Mr. Pritchett have a copy of whatever Detective Velasquez is looking at?
Served one in the motion, but I will give him an identical copy right now as well.
Great. Thank you. Does that leave you without one?
No.
Okay.
And after speaking with Ms. Mitchell, what were you able to determine?
I was able to get surveillance video of what she felt being the manager in relation to the time frame the incident happened with the 911 call that showed 3 black males entering a pedestrian gate, identifiable from the camera view. I was provided a copy of that video, and at that point I released that video to the media, asking for the public's assistance through Crime Stoppers to identify those people.
I'm going to show you what has been admitted as State's Exhibit 37. It is a conviction, a first offender plea for Max Pritchett, and then as well the sentencing for the actual adjudication of guilt. You recognize the name of that indictment?
I do.
Okay. And are all of those subjects that you were able to develop as being involved with this burglary, home invasion style burglary of Mr. Greer's apartment?
Yes.
Okay. Will you please read to the jury the names that you identified as being part of this burglary?
Frederick Jamal Clark, Voss, VAS Coleman, Max Pritchett, Mark Steven Spencer Jr., and Lil Shay, Lilche Stafford.
How were you able to develop those names as suspects in this particular investigation?
Through Crime Stopper tips as well as social media.
Okay.
Sir?
On the admission of the exhibit, can there be a specification on what type of adjudication of guilt that was? What type of plea that was?
For you?
Yes.
So two things. It's in the record, so it will say. Two, you'll have an opportunity to cross-examine the witness. So if you feel like something wasn't sufficiently clarified, you'll be able to get this witness to read from the records in the same way he just did when he said, "Here are the people who were charged." Okay.
Sorry, so you
Give it
said
time
you
to learn how to
develop
lawyer.
social media. Now, the individuals that you were able to come across that are on that indictment, did any or multiple of those have nicknames that they went by?
Yes.
Okay. What are the names that you recall? Do you recall if Max Pritchett had a nickname?
I do. He had a social media handle. May I refer to my report?
Yes.
And for the record, this is my whole investigative file, my actual report.
We got another question. Did the name Rick Ware ever come up in your investigation?
Yes.
Okay. And how did that name come up in your investigation?
Rick Ware was the defendant's Instagram handle.
Okay. And the defendant being who?
Max Pritchett.
Okay. And do you see Max Pritchett in court today?
I do.
Okay. Would you please stand up and...
What's the objection?
That isn't in the investigation.
So why don't you,
take him on board.
Should you choose to cross-examine this witness, you'd be able to say, show me where it's in the investigation. But this witness has testified that he associates Rick Ware with, the jurors heard what he had to say about Rick Ware and you. So back to you, Mr. Hiles.
Okay. So you testified that Rick Ware was the Instagram handle. Did Max Pritchett have an actual different name for his Twitter? You recall?
He did.
Okay. And do you recall what the Twitter name was for Max Pritchett in this case?
It was Sartorial Savage.
Those were two separate social media accounts, correct?
Correct.
Okay. What about Voss Coleman? Do you recall any nicknames that Voss Coleman would have had?
Young Bands.
Young Bands?
BANS.
Okay. Now, were you able, at any point in time, did cell site location information or call detail records ever become a part of your investigation?
Yes.
Okay. And how did they become a part of your investigation?
I was able to get phone records for the defendant on trial today as well, and then transfer that information to one of our cell phone experts within the unit, was able to track those cell phone records using cell tower data and triangulate that location that coincided with the location of where the crime occurred around the time the crime occurred.
Okay. Now, did everybody that's on that indictment play the same role in this burglary of Jose Briere?
No.
Okay. Please tell the jurors what role, and if you need to look at the indictment that's in evidence, you're more than welcome to read from that. But tell the jurors by name and what role each individual played in this particular burglary.
This particular case, 5 suspects showed up at Mr. Greer's location. The 5 individuals that I named earlier: Mark Spencer, Frederick Clark, as well as Lachey Stafford, left the vehicle and actually went to the victim's door and were trying to get in and kick the door in eventually. The defendant, Max Pritchett, and Voss Coleman stayed in the car.
Okay. And through the course of your investigation, were you ever able to determine why Voss Coleman and Pritchett did not actually go into the apartment complex?
My investigation revealed that the group felt that Voss Coleman was too young. He was, I believe, 16 at the time. And the defendant, Max Pritchett, had an injured foot, and it was decided that he'd stay in the car because of that.
Okay. Was Mr. Pritchett determined to be the driver?
That's correct, he was.
Okay. So Mr. Pritchett drove Voss Coleman as well as the other three individuals to the incident location. And is that your testimony?
That is correct, yes.
Okay. And as they got out and actually made entry, is that correct?
That is correct.
Okay. Now, was there ever any property taken from this incident that you were able to track down?
Yes.
Okay. How were you able to track down that property?
So what was taken in the burglary was the victim's wallet, a work laptop, a work iPad, and a work cell phone, an iPhone. The victim worked for Comcast. Through my investigation, I was able to recover the laptop and this iPhone. The wallet surfaced later through my investigation, where one of the defendants, Lachey Stafford, displayed the victim's ID, and the person they displayed the victim's ID to, and the wallet and credit cards, had seen the Crime Stopper story and recognized the photo of the victim, and then reached out to me.
Okay. Were you ever, what was the date of this crime again?
December 8th, 2015.
And did you ever, how central to the investigation was the call detail records and the cell site location information?
Very essential. It allowed me to actually look at the suspects' cell phones that they had in their possession and triangulate that and actually put them at the crime scene.
Okay. And were you able to do so for all of the defendants that were charged?
I believe so.
Okay.
I believe all 5.
Okay. And did that reinforce what you had uncovered and believed to be so from the rest of your investigation?
It certainly corroborated a lot of the other information that I received, yes.
And those call detail records and cell site location information, is that something that you would have, or that you did compile and place in your investigative file?
Yes.
And is your investigative file more than just this 40-page report?
Oh, yes. It's 3-ring binder, probably that thick.
Okay. And was those records part of the file that would have been turned over to the district attorney's office for the prosecution of this case?
Yes.
I know there was a lot more that went into this, but is this the absolute abbreviated version of what's going on throughout the course of the investigation?
Very, very abbreviated, yes.
All right, I don't have any other questions for this detective.
All right. Ms. Mignot, do you have any questions for retired Detective Velasquez?
Very briefly.
Good morning, Detective Velasquez.
Good morning.
As it pertains to your investigation and your involvement in the December 8th, 2015 case, my client, Mr. Tyrone Robinson, had absolutely no involvement in that case, correct?
Never heard his name mentioned.
Thank you. Nothing further.
And turning to the accused, sir, do you have questions for the witness?
Yes.
Great. Come to the podium, please.
This should be good.
Greetings, Mr. Velasquez. How you doing today, sir?
Good, sir. Thank you.
With the exhibit that the state just handed you, I believe it was a plea agreement. Can you read on there, if you can find it, the specification of that plea, like what type of plea specified on there that was taken by me?
Okay, if you just allow me a minute to read through it.
I wonder if he opens the door.
So I think the question is, and I'm not in any way putting words in your mouth, but we call them final dispositions. So ultimately the case was resolved, and part of what Mr. Hiles tendered as states 37, and I think it's going to be about the next document he's going to get to, is that initial final disposition, which it sounds like involved the plea, but we'll let the witness look at it. One more page, and there's a final disposition.
Understood.
All right. So if there's a part of, you've got it too, if he's looking at the same page, if there's part of it you want him to look at.
Actually, I don't have it.
Okay, it's in your stack.
Not in there. I don't have it. I don't have that copy or that final disposition.
Okay, how do we get one for the witness, for the questioner to look at, Mr. Hiles? So there can be one in front of the witness and one for Mr. Pritchett to have.
Would you like to look at the original archive?
Appreciate it.
And we're at the final disposition.
Okay.
Yeah, this is roughly the question. And it has the wording. The wording makes it sound like it's not so bad. Let's see if you can find it.
Okay,
So now the questioner, the accused, is reading the certified version, which is not redacted. He might accidentally read something that's redacted on the version that's in front of the witness, which in theory could open the door to
looking
information.
at that final disposition, Mr. Velasquez, you should see that box in the middle of the page, correct?
Yes, sir.
Okay. Now, next to count 2, if you go over to your right, past the OCGA numbers, what does that disposition say?
First offender, Alfred.
Do you know what an Alfred plea is?
I'm not an attorney, and I don't think I'm qualified to instruct the jury what an Alfred plea is. That would be for an attorney to explain to the jury, not
Mr. McBurney, can you instruct the jury what an Alfred plea is?
Judge?
It's not a question.
Probably not my role right now, but there may be an opportunity for you to get that in front of the jury through different means. But this witness has said he's not the right one to talk about an Alfred plea.
Okay. So in all your years of experience, you don't know that Alfred plea means that you maintain your innocence. You don't know that.
So it would be improper for me as a non-lawyer to offer advice or an opinion on a legal conclusion of what an Alfred plea is. I'm a detective, not an attorney.
Allows the
now, in
defendant
this
to plead
case in
guilty
2016 that you
and accept a plea
investigated,
bargain while still saying
well,
they're
first
not
let me
guilty.
go back. You said you've been a detective for 22 years, correct?
Well, I was a police officer for 22 and a detective for 17.
Now, when you go to the process of charging individuals or suspects to a crime, that's on your discretion, correct?
So charging and arresting are two different things.
Mm-hmm.
So my job is to look for what's called probable cause, and that's gathering enough evidence that's sufficient to support the arrest and the charge of, in this case, burglary. So the decision would be up to me once I feel that there is enough probable cause. And then I present that evidence to a judge, and the judge has to agree to sign the warrant.
Okay, so in specification, in that investigation of 2016, that led you to charge me as a party to a crime, correct?
Correct.
Okay. And
I'm worried he's going to open the door.
According to your investigation, you charged me as a party of a crime specifically because you believed, according to your investigation, that I was the supposed getaway driver?
That was part of it. There were other aspects of your involvement that I have not testified to this jury about yet, but that's part of it, being the driver, yes.
So what was the main part of why you charged me with party to a crime?
So I would have to read the warrant to be specific, but my recollection right now, there was a piece of it where co-defendant testimony, co-defendant information, cooperating co-defendant, Frederick Clark, as you're aware of, provided information that you were part of the planning process of this at the house that you rented with Mark Spencer on Mitchell Street. You were part and parcel to the planning phase of this crime. That, along with physical evidence that put you at the crime scene, as well as
this is so bad,
as well as just other evidence that shows that you were part of this as far as being present.
Okay, and you remember getting statements from Voss Coleman too, correct?
I do.
Okay. And you recall him stating in contradiction to Mr. Clark that there was no planning at that location?
I'd have to read the transcript from the statement from Mr. Coleman. I don't recall exactly what Mr. Coleman said.
Do you have that in front of you on your investigative notes?
No, sir, I did not.
I thought he said he had the whole investigative file with him. He can't create his own mistrial by opening the door to to prejudicial information. If he opens the door, he made his bed and he gets to sleep.
What did Mr. Clark state to you that I helped plan? Like, what was he say was my involvement in the planning? What was said by me that suspected my help in planning? What was said by me in that plan?
I don't recall exactly, but the gist of the conversation was there was a guy named Cash who the target of the burglary that was a drug dealer, and that this conversation took place at your apartment where you and Mark Spencer lived, in either your room or Mr. Spencer's room, I can't recall which one, and that the plan was hatched that all five of you would participate in breaking into the drug dealer's home. Unfortunately, they got the wrong apartment. And that you were part and parcel to the conversation of where it was, the location of where the apartment was, the complex, I think it was called Skylofts, and that you willingly went with that group, waited in the car, knowing that they were going to go in and break into the apartment.
Okay. And I was the getaway driver.
Yeah, but that's your
I don't know if the word getaway driver was used, but you were the driver.
You don't recall in your warrant you specifying that I was the supposed getaway driver?
I could have written that. I just don't recall. Okay. And if I did write that, then that was what was stated by Mr. Clark.
Okay.
So they broke into the wrong apartment. The victim, out of fear, jumped off the third floor balcony and died as a result of the jump or the fall. And because of that, because they were committing a felony when it happened.
You do recall a statement from Voss Coleman, correct? In part of your investigation.
I remember Voss Coleman gave a statement. I just don't recall exactly.
You don't have these papers in front of you?
I do. If you want to refer me to what page?
This
is a pro se.
Page numbers on it, but it is.
Should be at the bottom of the page. Page number, right under the date.
36. Yeah, you're right.
Okay.
36.
So you're asking the witness to read page 36 to refresh his recollection about what Voss Coleman said?
Yes.
Okay.
So he's literally
and what was your question,
soliciting
sir?
hearsay, but he would be the one to object. I don't think he's going to object.
Please pardon me. Please
Certainly.
pardon me.
Certainly.
I'm not sure if the judge will
If we
stop.
can actually just go back to 26 first,
26.
just so I can keep an order of things.
The state might object if it
Okay,
serves,
I'm
if
there.
it helps him.
Now you see in that the first sentence where Clark states in his statement that he transported Spencer, Pritchett, Stafford, and Coleman to the location in his black Honda car.
Objection. You can't read from the.
Right. So you don't read it.
Okay.
You just,
I'm sorry.
indicate to the witness what section you want him to read. When he's done reading it, then we'll see if that has refreshed his recollection.
Can you read that second sentence? Starts off with the letter Clark. I mean the word Clark. Second sentence.
Second says Clark transported Spencer, Pritchett, Stafford, and Coleman to the location.
Objection. You can refresh your.
You can't read.
Right. So I'm sorry. I thought we'd done this, but it was with a different witness. So a lawyer questioning you can put anything he or she wants in front of you to read to yourself, not out loud. And then when you're done reading whatever part the questioner has said, hey, look at this. When you're done reading it to yourself, then look back up, and then the questioner will say, all right, did that refresh your recollection? And you say, yes, it did. And this is what Voss said, or nope, I read those words, but I don't remember that having happened. So have you read the part that Mr. Pritchett wanted you to read?
I have.
All right. What's your question?
So after refreshing your memory, it's correct to say that Clark is the one that transported individuals to that location during that incident, correct?
He did in his car. Correct.
Evangeline Light, thank you so much.
No.
Wonderful 12 months. Congratulations.
Now, can we please go to page 36? Just want to refresh your memory.
They're already on page
Okay.
36.
Can you read that fourth sentence that starts off with Coleman said?
Read to yourself.
On page 36?
Yes, sir. Fourth sentence that says Coleman said that he.
Are you sure you're on page 36? 'Cause I don't see that.
What are the first two words at the top of the page? You can read those out loud.
To speak.
Yes, that's the page I'm on. So after that period right there at present, go down 1, 2, 3. So it'll be the third sentence from that period at the top. Where it starts off, it says Coleman said.
They're on different pages.
Okay. For the record, it's the sixth sentence down from the top.
That's okay. As long as you found one that fits that description.
Make sure we're on the same.
Yeah. If you'll read it, and then we'll see what Mr. Pritchett wants.
Sorry about that. I only saw 3 periods.
No worries, sir. I've read it.
Okay. Now, according to Coleman's statement, now that you refreshed your memory,
So you don't want to read the statement.
Yeah, I don't want to read
So does that refresh your recollection about what Coleman said?
Does that refresh your recollection of what Coleman said after reading that?
Yes, sir, it does.
Okay. Now you can confirm that according to Coleman, once 3 individuals left that vehicle, him and Max went to Wendy's to get food?
Is the question, could I confirm that?
Can you confirm that?
No, that was not confirmed. In fact, there's a video that exists showing those defendants going to Mark Spencer. Frederick Clark and Lachey Stafford going to a Krispy Kreme donut shop.
Yeah, but I'm not referring to them. According to Coleman, after the individuals left the vehicle, correct? According to Coleman, where did Coleman and Max go after they left that vehicle?
Well, I don't know. So the evidence of the entire investigation shows that Max Pritchett and Voss Coleman remained there, and then the other three defendants jumped the wall after the burglary and got in the car and they left. Voss Coleman, according to his statement, stated that you and he went to Wendy's.
Okay.
That was I was unable to corroborate that at all. Okay. There was no evidence to support that statement.
So in your investigation, Voss Coleman didn't show you a video, or I don't know if it was you specifically, but it was detectives in the interrogation room that he did get food from Wendy's and he happened to have a video showing that food.
So don't answer the question yet. Yes, sir.
It's not a question, he's talking about facts outside of evidence.
So make sure you're asking questions rather than trying to introduce evidence by saying, hey, isn't, there's this or that. So what's your question for Detective Velasquez?
So according to Coleman, Max and him went to Wendy's to get food, correct?
That's correct.
Okay.
I guess robbery makes you hungry.
So we know, according to your investigation, that Max didn't drive anybody to the crime scene, correct?
That's correct.
Okay. And according to your investigation, after the incident occurred, the three individuals that were supposedly entered that apartment, once they exited that apartment, they ran to a Krispy Kreme, correct? According to your investigation?
So I don't recall whether they ran or were driven there. They ended up at the Krispy Kreme.
Can you go to page 27 to please refresh your memory?
What part of 27? And if you go by line number rather than sentence, that's easier. Just count down lines, so you don't have to worry about periods.
It starts on line 2, the end of line 2.
And how much do you want them to read? The whole page, or?
You can just read read all the way down to line 6.
I've read it.
Okay. So now, after your memory has been refreshed, how did Clark and the other individuals get to Krispy Kreme?
They ran on foot.
Okay.
So he's doing an okay job.
Now, after
blundering through
these
this,
individuals,
I'm not sure if he can get the big finish in that he wants.
Arrived at Krispy Kreme, what did Clark state that they did at Krispy Kreme?
I don't recall.
Refresh your recollection.
Okay. You don't recall Clark stating that I don't see it on this page either. You know what? Okay. Once at Krispy Kreme, according to Clark's statement, it was realized that he had to still get to his final destination, correct?
Who are you referring to?
Clark.
Yes.
And, okay.
Answer is yes.
Now, at Krispy Kreme, according to your investigation, how did Clark and the other individual with him get to their final destination?
They took an Uber on Clark's account.
So Clark didn't call me, the supposed getaway driver, and call me to pick him up from Krispy Kreme?
So while Mr. Greer is on the phone with 911,
That was a yes or no. It was yes or no. Did he call me to pick him up from Krispy Kreme and to take him to his final destination?
So witnesses can explain their answers. So at some point there'll be a yes or no, or I don't know, or maybe, but the witnesses are always allowed to explain their answers.
I didn't want any confusion. Continue on, sir.
So according to Clark, as the call went over 911, as they're running out, there is an Atlanta police officer entering the complex responding to the call. That was corroborated by a witness that was standing in the parking lot. And according to Clark, once that happened, the original plan was for this defendant to be the driver. But once that happened, they all scattered and their plans changed. Krispy Kreme was never in the plan to go there. So none of that happened, and there was no call to you. There was no record of a call from Mr. Clark to you, to answer your question, to pick you up. Whether there was or, I don't know if there was a call, what it would be for, but there was no record of a call immediately to you.
Evangeline, thank you so much.
I mean, if there was a call, the reason for the call to me would be, since I was this planned supposed getaway driver.
Objection, speculation.
Judge is going to help him out here.
You can finish the question, but if it's asking this witness to say, yeah, maybe that's what you guys were thinking, he can't speculate as to what the plan may have been, unless someone told him what the plan was.
So what he's trying to do is say...
So was it ever stated specifically in Clark's or Coleman's statement that I was the supposed getaway driver?
So Clark drove them there, and
I believe
drive him away.
Not
so
in Coleman's statement, but in Clark's statement, I believe, yes. That you were to remain in the car with Mr. Coleman and drive when he got back.
He said specifically that I was supposed to drive when he got back.
I'm not sure if the word getaway driver was used or driver, but there was conversation that encompassed that thought process.
He's,
Page 26.
He's almost saying, well, I remember it differently. It's just...
Have you read it?
The whole page or a certain line?
Line 6, 7, line 5, 6, 7.
Yes.
Okay, now I'm assuming, correct me if I'm wrong, are those the lines from Clark's statement that caused investigators to think that I was the supposed getaway driver?
So this report that you're reading doesn't encompass anybody's complete statement. I chose what to include in here, knowing that the statement itself is available for reference.
Okay.
So this doesn't encompass Mr. Clark's entire statement.
Okay.
It's not a verbatim recordation of what Mr. Clark said when you were talking with him.
That is correct. It is not.
So you chose to leave out that Clark told you or detectives that I was supposed to be the getaway driver. You chose to leave that information out of the investigation report?
There's a lot of what Mr. Clark said in his statement. Probably, in fact, he gave two statements. And I believe the first one is over an hour long. So it is not common for me or any other detective to verbatim write in my report what that witness or suspect says. It's referred to as a brief encounter. So my job is to document the encounter, the witness or the suspect statement. This one happened to be with his attorney. And then also indicate that that statement is available in the file for review. So it's not a matter of what I choose. It's more of documenting what I need to document that statement occurred. And then we have the affidavit for the warrant, which may be a little more specific as to the defendant's involvement based on what another witness or another suspect.
So again, you chose not to document that Clark stated that Max was supposed to be the getaway driver.
Well, if it's not in here, then yes.
Okay. But you believe that in his statement that he said specifically that Max was supposed to be the getaway driver?
Again, as I testified to earlier, I don't recall if he actually said those words or the word getaway driver was used, but the gist of that conversation was that you were to drive away. But I can't tell you verbatim what he said without the statement in front of me, without looking at the entire statement.
I thought the gist of what he said was that I had a hurt leg or foot, so I decided to stay in the car.
Stop. Don't read from the report. You can summarize it, but make sure you're not reading to the jury from the report.
Is the gist of what he said that I was supposed to be the getaway driver, or was the gist of what he said was that I was supposed to stay in the car because I had a hurt foot?
So I don't know what you mean by gist, first of all.
Gist, I mean,
let me finish, sir. Let me finish. Okay. Let me finish my testimony. When I write my report, what I reference is that a statement was taken, and the statement itself is always available for everyone to review, knowing that the prosecutor is going to get it, and that in discovery, you would get it. So I'm not required, again, to write down everything that a suspect or a witness says verbatim. So I can't testify to what the gist is. I understand what gist means. I can't testify to what my intention was for the gist. I documented what I felt I needed to document on that particular statement. The rest is available for review in the actual statement itself.
Okay. And so it's correct to say that you felt that you shouldn't have documented that Clark stated that Max was the getaway driver.
Objection, asked and answered.
We've covered it. Let's go to a different area.
All right. Okay, so now, according to your investigation, Clark gets an Uber from Krispy Kreme to 836 Mitchell Street, correct?
Correct.
Okay. Now, once arriving at their final destination, Clark and another individual realized, did Clark and another individual realize that they had left stolen items stashed somewhere, according to your investigation?
Clark, I believe, and Spencer did, yes.
And they realized that once at their final destination, that they had actually left some stashed items that they have retrieved?
I'm not sure I understand the question.
According to your investigation, it's correct that, again, Clark and Spencer, once at their final destination of 836 Mitchell Street, realized that they had left stolen items that they needed to retrieve, correct?
They intentionally, according to Clark, stashed the book bag with the stolen items, yes.
Now, did they ever go back and get those stolen items?
Yes.
How did they go get those stolen items?
They were transported by a person, his first name was Corey. I don't recall his last name. It's in my report. If you need it, you can direct me to it. But he then arrived in his own vehicle and transported them back to the location, which is literally right near the crime scene, and retrieved the bag with the stolen items.
So Clark and Spencer didn't call Max? Didn't call me?
I don't recall what calls were taking place without the phone records in front of me. But as far as it being transported to pick up that bag of stolen property, it was a person named Corey that did that.
So it's safe to say that I didn't drive anybody from that crime scene to any other location, nor did I drive anybody after the fact to retrieve any stolen items that might have came from that crime scene location, correct?
Correct.
So according to your investigation, in Coleman's statement, the only driving that I did was after the alleged assailants leaving that vehicle. According to the investigation in Coleman's statement, the only driving that I did was go to Wendy's to get food, correct?
According to Coleman, that's what he stated. I was unable to verify whether that happened or not.
But was there any other evidence that I drove any of the assailants after the fact, during or before the fact, to any location having to do with the crime scene?
No.
You got a point. There's no evidence that he drove at all, apparently. I'd say no further questions.
Okay.
Malpoy, you're right. The hearing for the Kelly decision on retrying Mr. Kelly in Arizona.
According to your investigation, there was no evidence that I aided or abetted in this crime in any way, was there?
Oh, there was. That's why I arrested you.
What was that evidence?
It's in the affidavit, sir. I had signed an affidavit, swore to it in front of a judge.
You don't
let him finish his answer.
Okay,
you can follow up.
So, and again, I've testified the fact that co-defendant gave information that you were part of the planning phase of this. The fact that, and Judge, I'm trying to be careful what I say that's in because there was other evidence that supported your arrest that I don't think it would be proper for me to testify to. That was part of the affidavit that met the standard of probable cause for your arrest.
Does someone have a copy of the affidavit that I can look at?
Just the accused has the.
It's not. I guess that wouldn't be part of your file. As a result of your file, you get the affidavit.
The affidavit is part of the file.
You've got it there?
I do not have it with me, but it's part of the main file that I turned over.
Okay.
Again, it's pretty big file.
No, I understand.
And again, I'm just trying to be careful with what
No. I appreciate that too. That's why if I could see the affidavit, I could help us navigate this.
Understood.
No affidavit.
I'm not the one with the evidence, so I don't know if you've got a copy of the affidavit. I'm looking to Mr. Hiles, and we'll see what happens. Why don't you ask a different question if you've got any more? If not, I'm happy to wait to get my hands on the affidavit.
From what your recollections brings up to you, what other evidence are you referring to?
Oh, open the door.
So that's where I don't want to be prejudicial towards you, and I'm trying to be careful with what I say. I don't think it would be.
So, Mr. Pritchett, remember, I made a ruling there. There's one part of this case that the burglary case that we're talking about that I've excluded, and the detective, I think, is wanting to make sure he doesn't get into that space, and I excluded it for your benefit, not the state's benefit.
You're right. I was just trying to see the evidence directly towards.
Your question is a perfectly appropriate one. I think the detective is just leery of, in saying something, it gets into the area that I concluded wasn't sufficiently relevant to this case for it to come in. But it would be great if I had a copy of that affidavit and I could help.
I know it's cross-exam. Can I just inquire if you're talking about the arrest warrants? Is that the affidavit?
Yes, and I want to be careful. I'd like to read it as well.
Sure, and that's what I'm assuming is the affidavit for the arrest warrant.
I may be able to help. I think I may have a copy of my Dropbox that I could maybe, if I'm allowed.
I can't tell from reading Mr. House's body language if he's found it or he's a good poker player. He's just looking at the screen. It's there, it's not there. So if he sends it to me, I'll print it out and I'll print 3 copies. So one for Mr. Hiles, one for the accused, and one for you to look at as a recollection refresher.
The judge and this witness are holding the door shut in spite of the accused's efforts to throw it open.
One PDF of all of the investments.
Okay, here it is.
Throw it up on the screen. He's literally asked, what other evidence was there to arrest me? And that other evidence has to do with the fact that there was somebody that died as a result of this robbery, which it's going to be bad. It's going to be bad.
I have a question in the meantime.
All right, just give me a second. I'm trying to find the right one.
So this witness entirely is only about Mr. Pritchett. This is not talking anything about Mr. Robinson, and this is the prior act. Yes, it is quite prejudicial, but because it was there's a gang affiliation charge in this current case, because the way the law is written down in Georgia, that this type of prior act is allowed to come in, where normally it would not.
Affidavits are all going to be
The same. I'm just making sure of that. All right, they'll pop out on the printer in a minute. Do you have other questions, or really where you're wrapping up is with this affidavit?
Yeah, pretty much that affidavit.
Okay, you can hear it coming right now.
Okay.
Thank you, Mr. Hiles.
I will say that if the defendant opens the door, it doesn't cause a mistrial. You can't cause your own mistrial. So if he opens the door, basically it seals his fate in many ways. But the judge put the ruling in place to protect him, and he's the only one that can. Or when I say he, the accused is the only one that can throw that door open. Nobody else can. If the state brought a question out and asked this witness something, and he said, "Yeah, well, once we recovered the body from the original murder scene, the original robbery scene," that would be mistrial immediately. It would be over. But if the accused opens the door and the guy says that on the stand, and that answer is elicited by him,
there's one for you.
Judge, like, I tried, but now it's fair game. And then the state does get the right to be able to go and explore it further. It's like now this is thrown open. The jury has questions. We have the right to explain.
Mr. Pritchett. Mr. Hiles.
Yeah, let's go into his background a little bit. Or how many jurors, know about that case? I wonder if they were asked about that.
Let me know when you refresh, Jeff.
The jury can't open the door, though. Even if they have suspicions and they're asking, the jury cannot open that door. The individual who jumped, he was the resident at the apartment that was being robbed, and it was the wrong apartment. It was not the target that they originally were supposed to go to.
Okay, I'm ready.
I'm ready to, you can go.
Okay,
So repeat your question because we had a little bit of a break.
yeah, we did, wow, kind of forgot it myself. Let's go back to, because you let me just restate this again. So the evidence that caused you and your department to charge me as a suspect to this crime is that I participated in the planning of the crime?
The planning of the crime, your presence at the crime scene, and then your actions after the crime occurred. From information received from Mr. Clark, as far as hiding out at a Motel 6. Some corroboration through Uber records supported that statement from Mr. Clark. Your Uber records in particular, that actually shows
that I was hiding out at a Motel 6.
Well, it shows you taking a car from 836 Mitchell Street to the address where Motel 6 exists. So that's corroboration to what Mr. Clark says.
So was I hiding out at Motel 6? Did I get a...
I don't know if you were there or not. I know you ordered an Uber to that location the day after the homicide. Okay. I'm sorry, the day after the case.
He said it. He said it.
Where was I arrested?
He said homicide.
In the Bronx, New York.
If the accused asks for a mistrial right now, he might get it.
Where was Lachey Stafford arrested at?
But he doesn't know.
Lachey Stafford was arrested, I believe, at the airport in Denver, Colorado. I think you were with him at the time.
And I wasn't arrested then, though, correct?
You were not. I didn't have an arrest warrant for you at that point.
Okay, so what was that specific evidence that you needed to get an arrest warrant?
In the time that Lachey Stafford was arrested, I'm not sure where I was in the investigation. And for the record, there was 5 defendants, and I was piecing it together piece by piece. So obviously the evidence that I felt supported an arrest came after that. In fact, when Lachey Stafford was arrested, I had information that he was catching that flight. So I sent our fugitive unit to Denver airport to pick him up, not knowing you would be with him. And they called me to ask about you. And I specifically told them to let him go because I do not have a warrant for him. And I think it was shortly after that date that I obtained the warrant. And later we found you at your uncle's house in the Bronx, New York.
Okay. So just for clarification, the only thing that caused you to place charges on me as a suspect to this crime is because it is alleged by Clark that I was part of the planning process of this crime.
Well, part of what I was able to determine is that none of the 5 defendants, including yourself, had any relation to Skyloft Apartments, to the victim, Mr. Greer, anyone that lived there. You were there. You were at that location when this crime occurred, and co-defendants admitted their participation in it. Your phone record supported that. Testimony from your co-defendant, Mr. Clark, that you were part and parcel to the planning phase of this beforehand. And then part of what we consider evidence is flight after a crime occurs. And we were able to determine that you, through corroborating your Uber records, went to a motel, as Mr. Clark stated, to hide out, and at some point ended up in New York City with your uncle. So that's the evidence. Your phone records, co-defendant testimony, and ultimately pled guilty.
So under Alfred, which is what to maintain my innocence. But again, none of that flight information that you suspecting me of is in this affidavit, correct? Because you said I was flight, but it wasn't in your affidavit, though, correct?
No,
it wasn't in your affidavit for the arrest warrant.
It is not needed for that. My warrant, the probable cause that I presented was sufficient. And not everything goes into an affidavit. I put in what I need, what I feel is sufficient to support an arrest. And many times there's way more evidence that I put in the affidavit. A judge has to read it. I have to be mindful of a judge's time. So try to keep my affidavits to the point. So although it's not in the affidavit, it's still evidence.
But this is the affidavit that supported your arrest for me, correct?
Correct.
He thinks that the evidence should be limited to what's in the affidavit, and that's not how it works. There's
so on your affidavit that supported the arrest for levels. Me, what supported your arrest for me?
So we've covered that now.
And specifically on the affidavit, we have it.
So this witness has now testified every which way about what he thought supported probable cause, what was in the affidavit. You've highlighted some things that he indicated that weren't in the affidavit, but also supported your connection to the case. So I'm going to ask you to move to a different area now, if you've got a different area.
I'm just trying to make a point, sir.
I understand the point you're making, and my point is you've made your point. So it's time to make a different point.
So is it possible?
I bet he doesn't move on.
According to your investigation and the statements that you received from Clark and Coleman,
he hasn't moved on.
Is it possible that the plan that you say I participated in for this crime was that once the other three assailants got out that car that night, the plan was for me and Coleman to get food? Could that have possibly been the plan of what was supposed to happen that night?
According to the evidence that I've gathered, no.
Why is that a no, sir?
Well, sir, this case could have gone to trial, and I think that would have been for a different jury to make that decision. So I stand on what my evidence is, what my investigation revealed, and what the probable cause was for your arrest. That's all I can testify to.
But if the only evidence that you're relying on to say that is that you have phone records that put me in the scene of that crime, which corroborates what Clark and Coleman said. But what they also said is that I left that crime scene to go get food at Wendy's, which was right in that area of that crime scene.
So, Mr. Pritchett, we're again going around in a little bit of circles. You are going to have an opportunity to argue to the jury if you think it's relevant to, of course, the case we're here for, which is Wiley Street and not Oak Street. If you think there were some deficiencies in the Oak Street case, you can talk to the jury about that. But Detective Velasquez has now said 3 or 4 times what he's got to say about the work he did on that.
Are you familiar with this case, with this present case?
I am not.
Yeah.
Hey, Legal Vices, welcome. Good to have you here.
No further questions, Judge.
Mr. Hiles, any redirect?
No, Your Honor.
Any questions from the jurors?
Please have questions. Okay, this is a lesson in why to have a lawyer, and it's painful. It hurts. Fingernails on the chalkboard, painful. If you're just joining us for the first time today, you're going to notice that the jurors are going to be led out of the room, and you will see them on camera. The judge is aware of this. He says it's a public courtroom. He knows that they're going to be caught incidentally, and sometimes completely on camera. Yes, the defendant did let it slip that there was a homicide on the last robbery. That was the quiet part that was not supposed to be said out loud.
All right, ladies and gentlemen, I'm going to have you take your morning break right now. I'll cover these with the parties. We'll bring you back out, and we'll have Investigator Velasquez answer the proper questions. Don't talk about the case back in the jury room. No outside research. We'll see you in a moment.
So the jury is going to walk out there behind the witness who's blocking the camera for them. Thank you. That's nice of you. We have 13 jurors now, just one alternate and 12 deliberating jurors. The one alternate does have a master's degree hooding ceremony to go to on Wednesday, and the judge says maybe we can all go. We'll take a break.
All right, Mr. Hiles, if you would grab these, share them with Ms. Mignot and Mr. Pritchett.
Judge, was this meant to be an exhibit?
Nope. Thanks.
Oh, yeah, I'll take
I don't think he can get the mistrial and the homicide part.
Thank you.
It was
so we'll discuss these real briefly, and then I'll give everyone a quick break before we bring the jurors back in. I will not ask question 69, which is an inquiry about the nature of the victim's injuries. I will explore with investigator what he knows or can tell from States 37, which may need to come back to him, about whether there was a trial and the outcome for Mr. Pritchett. I'll ask the question about Clark and his car and a firearm, and what's the answer, if you know, Mr. Hiles, to the question about gang activity?
So I don't think it's, I was gonna bring another person involved in the investigation to talk about some of the gang activity.
That would be a witness you didn't tell us about.
No, it was Liam Packer and Demeester both.
No, meaning you said you have two witnesses left.
Well, what I'm saying is I opted not to do it because of the pace of the trial, and I didn't find it to be necessary.
Okay, but is this someone who can answer that question?
I have to ask.
I guess we'll ask him. Do you have any objection to that question?
No, I mean.
Okay.
This is Judge Robert.
Did you have any objection to any of the questions other than the one I'm not asking about the nature of the injuries?
No objection, Your Honor.
Okay. Hey, I need to talk to Mr. Pritchett first. Mr. Pritchett, did you have an objection to any of the questions other than the one about the nature of the injuries to the victim?
To the gang-related question.
You have an objection to that? Yes. What's your objection?
That in the evidence of their case, that were gang-related.
Was it?
I think it's ready to answer.
I don't have the indictment in front of me.
There was no gang charges alleged. It was stuff that was discovered post adjudication.
Okay, then I won't ask it. So there'll be two I don't ask. One, nature of the injuries, and then the thing about gang activity. Otherwise, I'll ask the questions. All right, let's take a quick break, and then we'll wrap up with investigator.
we'd be happy to know that Investigator Miller just texted me. He said he's trying to make this fast.
Your Honor, can we get a time on this break? Is it a 3-minute, 2-minute, 1 minute?
4.
4 minutes.
More than you asked for.
Now you have 3. Yeah, the jurors might be able to piece things together based on what they're not being told. When you hear that a little robbery went down, a robbery that's unfortunately very frequent and common, home invasion robbery, and then you hear people go into hiding and they're caught at an airport trying to get away, or at the family's house in another city. You can piece things together, and you know that something went down that was a big deal. A big deal. So the jurors, I think they get the gist of what is being danced around in this case. All right, let's see, where are we? I've got my eye on the news that'll be following the Kelly case. If we get video from that, we're going to take that. That's going to be this afternoon, probably around 3:30 to 4:30, around that time, before that happens. So probably late in the day, we'll find out if the prosecutors want to retry the Kelly case down in Arizona. Realize there was a mistrial in the first one, but the jury came back, and it's an 8-person jury, came back 7 not guilty, 1 guilty. And it's a big expense to retry the whole case and do it over again. I think the state is going to say, no, we're not going to retry. But we'll see. We'll see what happens. Let's see. The Alford plea, do you guys understand what the Alford plea was? The Alford plea is where a defendant is pleading guilty to charges, but simultaneously at the same time maintaining their innocence. So for legal purposes, the punishment would be the same as if you were convicted or if you pled guilty. But it's just a unique little maneuver. It sometimes is seen as cooperating in some degree to avoid a harsher sentence. All right. I think it should be over. I think the state sees, the writing on the wall with 7 jurors not guilty and one outlier holdout of a guilty. I think they know that they just don't have the case. Now, that doesn't mean that he didn't do it. Okay? I've said this all along. It doesn't mean that he didn't do it. It means that they cannot prove it, and that's how the court system works. Melpoy, not a fan of Alford pleas. Next witness should be the last witness for the state. So the state should be resting today, and this goes to the defense, and there are 2 defenses. So it'll be interesting. The accused has provided a list of a whole bunch of people that he wants to call in this case. A bunch of his gang-affiliated buddies that are not on any of the witness lists thus far, have not been questioned in the case. The judge has told him that, all right, you can put pretty much any names forward you want, but I'm not going to allow you to bring in a couple people that buddies of yours who say, no, he didn't do this. He was with me. We were in Florida at the beach that day. He's not going to allow the alibi stuff coming in from these new names that are coming in. I think it's funny. I don't know if these guys know that he says, I want you to testify for me. Seems like it's going to be a circus when that happens. Anyway, he's got like 9 people on his witness list. Most of them have already testified for the state. And the judge is a little frustrated by that, saying you had a chance to cross-examine them. Why would you now call them again, or why should I allow you to call them again when you already got a shot? It seems to be wasting their time and the court's time. I have not followed the Ruby Frankie case enough to understand which pleas have been taken. It's a little waste of time to put a date into a calendar if they're just going to say, I don't want to continue with the trial. Yes, but the process, in case it doesn't go that way, they have to have the dates there, because you can't just indefinitely push something off and say, well, we're going to treat this later down the road a certain way. I don't know how to explain this better. The defendant's right to due process, there's also a right that the process moves forward, right? You can't be held indefinitely on charges like Sarah Boone. Really, I think that she is approaching that time where the court might say, if there are any more delays, she isn't being treated fairly. She's been held, 3, coming up on 4 years in jail, awaiting these charges, and that's a long time to wait to have your day in court. You need that speedy trial. She waived hers, apparently. She still denies that she ever did that, but apparently her lawyer waived it for her, which don't know how that happened. There should be her signature somewhere on a paper if that's how it went down. Let's see. Keeping an eye on the news out of Arizona to see if there's any updates, but nothing yet. Our witness is back. I think we've passed the 4-minute mark. It's like 110 degrees in here. So commence the remote. Oh, the air conditioning's off. Why? There we go. Just kicked in. Yeah. All right. The rejected juror says court doc number A21D0167. Parent 1. Pritchett's pro se pleading is not entirely clear in this regard, and we have construed the pleading liberally. So you think he wanted to fire his public defender, and the judge says he had a fairly long discussion with him about this verbally. So I'm not sure if the pleading is not well written, but the discussion, I think the judge felt confident that it was done correctly. Paula Mack, I was up early this morning sanding the walls. Then I was also up early this morning painting, and got the first layer of primer on, which we tinted to match the final layer, just so in case I miss a spot, it's better coverage. I should have the flooring in by tonight.
Question: what
the bathroom done by tomorrow.
I will guide you.
Okay.
There will not be. You don't have to guess around.
Yeah. Thanks.
Robert, I had to rip out.
All right, Mr. Rivers, are you ready? Mr. Hiles, anything before? Well, let's get back on the record in State versus Pritchett and Robinson. Anything, Mr. Hiles, before we bring the jurors back in?
No, Your Honor.
Ms. Mignot?
No, Your Honor.
Mr. Pritchett?
I would just ask for a mistrial. I believe he said homicide.
Boom.
He did, and then switched it, and wisely, no lawyer or you drew any attention to that. So I'm going to deny your motion for a mistrial. I am finding that to have been an inadvertent misstep by the witness, who otherwise was very scrupulously adhering to my ruling, to the point where he was unwilling to get into the contents of the affidavit without having it in front of him because he was worried he might cross the line. So, number one, I don't find it was anything prompted by the state. It was in response to one of your questions, not Mr. Hiles's. I don't think it was something that the witness held up his sleeve until an opportune moment in a narrative answer where he could slide that in, but that it was unintentional and quickly corrected, and no one drew any attention to it after it was quickly corrected. So I understand your motion, and it preserves your concern, so that if there is an appeal, you or someone arguing any appeal on your behalf will be able to challenge my ruling that denies the mistrial. Now, I'm going to offer up an alternative remedy, but think about it before you say, yes, that's what I want you to do. I would be willing to, I just don't think it's a good idea to tell the jurors, you may have heard the detective describe the crime in a certain way. I can even say, you heard him use the word homicide. You should disregard that. That's not what this case is about. The reason why I'm cautioning you is that will draw their attention back to it insofar as any juror even remembers that he said those words. But if your concern is that the word homicide is going to linger on the minds of the jurors, then I'm happy to tell them that they should disregard the use of the word. It was used in error, that the witness quickly corrected himself, and it inaccurately describes the case as they are to consider it. So I can give that curative instruction, but you should just weigh whether you want that against that necessarily draws attention to something that I don't think was particularly remarkable during the course of Velasquez's many, many, many answers to your many, many questions. What are your thoughts on that? Okay, so I will not give a curative instruction. I gave you that opportunity and you're saying no thank you. I understand why you'd say no thank you. I need to include the other two lawyers in the conversation. Mr. Hiles, do you have anything you want to add about the motion for mistrial, which I've denied, and the offer for a curative instruction?
I don't have anything, well, what I would want to add, there wasn't a simultaneous objection to that statement. Secondly, I would note, although I think you made a record of it, that those questions would have been brought out, if, you know, essentially those answers, that was brought out by the questioning of the defendant himself, which I think, being what evidence you have, opens the door that he could have tied it in. I think he did a good job not to, but if some of that stuff that he was asking about was unexplainably tied to evidence of the homicide, and so it was just inadvertent.
Okay, so I agree with you that it was inadvertent. I disagree with you that Mr. Pritchett in some way opened the door, but it was inadvertent. That's how I view this. You make a good point that I didn't, and that is that, and the record will show it, but there was no contemporaneous objection. Insofar as that might affect appeals later on, the first I am hearing of Mr. Pritchett's concern about the use of the word homicide is now after he had finished his cross-examination. Ms. Mignot, anything you want to add to this discussion?
No, Your Honor.
Okay, let's bring the jurors in, please.
If you will bring the jury.
I wonder how he did find out. I don't know if he has a digital device with him. I think he was all paper, but somebody must have called him, or he must have talked to somebody on his break. I'm not sure if he gets a phone call on a break. He has requested standby counsel, but the judge is even open to that.
Thank you, Deputy Gordon. Everyone else can be seated. We're back from the morning break, and I've got a few questions based on juror questions for Detective Velasquez, and we'll go from there. Sir, was there any evidence you uncovered of a firearm being used in connection with the burglary home invasion that you investigated?
No.
How did Mr. Clark get his car back, if that makes sense? Because it seems like he was separated from his car at some point. Was that something your investigation revealed, or one of the unsolved mysteries?
So his car made it back to 836 Mitchell Street, presumably driven by the defendant, and he was able to get his keys back and take back possession of his vehicle.
You should have States 37 in front of you. Are you able to tell from the final disposition, the first final disposition, if Mr. Pritchett went to trial or if he resolved his part of the case by way of a plea?
He pleaded to the case.
Okay, and we've heard this is an offered plea, whatever that means, but it's still a plea rather than a trial.
That is correct.
Okay. And does the final disposition, the first final disposition, indicate what he was sentenced to?
Yes. 10 years to serve, 2 years commuted to time served, balance of 8 years on probation.
Was there a second final disposition for Mr. Pritchett?
There is.
And when was that one, and what was that?
Perhaps you can help me, Judge. Am I looking at the? So
that's the first one. Is that the 10 serve 2? So keep going. One more there. So same case. Is that same case number for Mr. Pritchett?
Yes.
And then what's the date of that second final disposition?
Date of this final.
It's a big box that says received at the top.
February 10th. Oh, I'm looking at the wrong. Is that filed in office?
Yes.
February 10th, 2020.
Okay. And the disposition was changed. What was the new disposition?
For burglary in the first degree guilty, 20 years to serve.
All right. Mr. Hiles, do you have any questions for Investigator Velasquez based on that exchange?
Yes. So in reference to the question about the car, was it Mr. Clark's statement that it was Mr. Pritchett who took possession of Mr. Clark's car at the location of the burglary?
Yes.
Okay. And was Mr. Pritchett supposed to drive everybody afterwards?
According to Mr. Clark, yes.
Okay. And I believe he said it was it also said by Mr. Clark that this plan was disrupted because of the quick response of police?
Yes.
Okay. And would that presumably be from the 911 call we heard of Mr. Greer as this was taking place?
It would, yes.
Okay. And did the cell site location information match up with what Mr. Clark told you about who was to take the car, where it started from, and where it ended up?
Yes, the cell site location tracked from 836 Mitchell Street to the incident location and then back to 836 Mitchell Street.
That's all the questions I have.
Ms. Mignot, anything more for Detective Velasquez?
No, Your Honor.
And sir, the accused, any questions based on the exchange that I just had with Detective Velasquez?
According to Mr. Clark's statement in your investigation, did I drive any of those assailants that went to that apartment from that crime scene?
No, they took an Uber.
And after the fact, when Clark was at Krispy Kreme and he had a chance to call the supposed getaway driver. Who did he call to get to 836 Metro Street?
I can't testify who he had a chance to call. That would be a question for him.
How did he get to 836 Metro Street?
He used an Uber.
And once at 836 Metro Street, he realized he had to go back to the crime scene to retrieve stolen goods. Who did he call to retrieve those stolen goods?
I've testified a person named Corey.
All right. Thank you, sir, for your time. Appreciate it.
Wow.
Mr. Hiles, you can leave that right there.
Did
If
I
you
miss
get
one of the
the
accused?
exhibit off the witness stand and tell us who your next witness is, please.
Yes, the next witness is Investigator James J.P. Miller.
JP. This should be the final witness from the state.
You swear affirm testimony you will give the truth, the whole truth, nothing but the truth, self God. I can do it. State this way again for the record.
James Miller, Jamesmiller.
What country singer does he look like?
Investigator Miller, where are you currently employed?
Employed at the Fulton County District Attorney's Office.
How long have you been employed there?
Approximately 3 years, September 21.
Okay. What's your capacity at the Fulton County District Attorney's Office?
So I'm assigned to the Major Crimes Division, where I investigate primarily homicides, violent crimes, aggravated assaults on robberies. I also get tasked out with other cases such as high-profile cases, RICO cases, gang cases, or whatever else I may be investigating.
Okay. And how long have you been in law enforcement?
So I started my law enforcement career with Douglas County Sheriff's Office after I got out of the Marine Corps in 2009. I started out in corrections, working in the jail, started out in uniform patrol as well. Then I worked some crime suppression and gang investigations. I eventually went to DeKalb County Police Department, where I worked uniform patrol, crime suppression. I also investigated criminal street gangs. Then I was employed by Cherokee County District Attorney's Office in Blue Ridge, where I investigated homicides, aggravated assaults, violent crimes, gang cases, RICO cases, high-profile cases as well. And then September here.
Okay. In your law enforcement career, do you have any specific experience investigating gang crimes?
I do.
Okay, please tell the jury what that experience is.
So I have been investigating criminal street gangs since my very first law enforcement career, starting out in corrections, interviewing individuals that were in the jail that I saw as, or they relayed that they were gang members, and whether they were showing me signs and symbols. I also took several different criminal street gang investigator courses, such as the basic gang investigator course with Georgia Gang Investigators Association. I also have my intermediate certification through Georgia Gang Investigators Association, as well as an advanced gang investigator course through DeKalb County Police Department. I have over 200 plus hours in different gang courses, whether it be from various law enforcement agencies across the states. I've also attended, have had training received from like LAPD, different agencies from California, New York, and across the state.
Okay. Do you ever teach law enforcement on gang investigation?
I do. I regularly teach. Specifically, I usually get called to teach gang evidence, gang investigation courses, basic courses with Georgia Gang Investigators Association. I'm also a gang instructor for the Prosecuting Attorney Council of Georgia. So we host an advanced week-long course, usually once a year, that is taught alongside with me and other gang investigators, some prosecutors throughout the state. I also host intel meetings 2 times in specifically the Metro Atlanta region, 1 in Cobb County and 1 in Gwinnett County. With Georgia Gang Investigators Association, I hold a position specifically as the vice president of the Metro Atlanta region. So that county or that jurisdiction is Cobb County, Fulton County, DeKalb, Gwinnett, Rockdale, Henry County. So within that jurisdiction, I'm responsible for making sure the members of our organization have the most updated and best practices as far as prosecuting and investigating criminal street gangs.
Matthew, thanks for your version of the song. I got that. Thank you. I appreciate that. It was a good remix.
Okay. And have you, in your course of investigating gangs, gang crimes, have you ever interviewed any gang members?
Yes, very regularly.
Okay.
Very what?
Very regularly.
Regularly.
Yes.
Okay.
No, regularly.
That's different from rarely.
No, regular, on the regular.
On the regular. All right, we'll get with that.
Words are hard.
All right. And over the course of your, how many gang members would you say you've interviewed?
Hundreds. Honestly, I can't give you an accurate number. It's part of my day-to-day job. Just last week, I interviewed, I believe 1 last week.
Okay. All right. And during the course of your training and experience, have you had the chance to investigate the gang Young Slime Life, or YSL?
Yes, I have investigated criminal street gang activity of Young Slime Life.
Okay. How many Young Slime Life cases would you say that you've investigated over the course of your, I guess, law enforcement history?
I know it's more than 10. I don't know an accurate number, but I've investigated homicides, armed robberies, burglaries, white collar crimes involving them, shootings, thefts, vehicle thefts.
And, well, Your Honor, at this time, the state would tender Investigator Miller as an expert in criminal street gang investigations, criminal street gang activity, as well as the criminal street gang Young Slime Life.
Ms. Mignot, do you want to voir dire Investigator Miller as to his qualifications, or do you want to wait till you cross-examine him on other issues?
I'll wait till I cross-examine.
Okay, so you don't have any objection for me qualifying him for purposes of these proceedings as an expert in those fields?
No.
All right, and sir, the accused, do you have any questions? Do you want to question Investigator Miller as to his expert qualifications, or do you have any objection to me qualifying him as an expert witness in the 3 fields Mr. Hiles mentioned? I want to be clear. If you say I don't have any questions now, you'll still be able to cross-examine this witness. It's just the threshold. I need to see if there are any objections to having Investigator Miller qualified as an expert.
I do object.
Okay. And what's your basis for objecting?
He's never been in the gang.
Okay. All right. Have you ever been in a gang?
I have not, Your Honor.
All right. That may go to the weight of his testimony, but I do find that based on the testimony I've heard from Investigator Miller about his training, experience, and exposure, that for the purposes of this trial, he knows more than the layperson, which is the test for expert qualification. And you are qualified as an expert in the field of criminal street gangs, criminal street gang investigations, and in the nature and origins of YSL.
The accused is like, I think I'm the expert.
Did you put together, well, I'm showing you what's been marked as state 38. Did you put together a demonstrative aid in the form of a PowerPoint for your presentation to the jury today?
I have.
And have you had a chance to look at State's Exhibit 38?
I have.
Okay, and is that a full and complete copy of the PowerPoint that you have provided today?
It is.
Your Honor, at this time, the state of tender states exhibit 38, a demonstrative aid for the testimony of investigator James Miller.
All right, Ms. Mignot, beyond the many objections you've made and preserved and that we've litigated outside the presence of the jury, do you have any additional objections? Because you would be renewing all your previous objections right now. Do you have any additional objections to States 38 being introduced as a demonstrative aid only?
No objection to 38 other than the ones we struck.
Okay, they are preserved and renewed. Mr. Pritchett, the accused, do you have any additional objections to the admission of States 38 as a demonstrative aid beyond the objections you've already made outside the presence of the jury that we've already litigated? Okay, you are preserving your objections as well. They are renewed here, and 38 is admitted subject to all those objections and changes that have been made to States 38 as a result of some of those objections.
Now I am showing you what has been labeled as States Exhibit 39. Okay. And as part of your investigation into this particular case, did you find related, I guess, music videos that you found pertinent to this particular case?
I did.
Okay. And were those two music videos titled Play Nasty as well as Guns Up?
That is correct.
Okay. And do you recognize the thumb drive that is in front of you as containing those two particular videos?
It is.
Okay. Your Honor, at this time, the state would move State's Exhibit number 39, music videos, Play Nasty and Guns Up, into evidence.
All right. Before I turn to Ms. Mignot and the accused for any objections, State's Exhibit 39 is very much like State's Exhibit 37. It is evidence that you all should consider, if you consider it in any way, as to only one defendant, but it's the other defendant. State's Exhibit 39, two videos. Should the state publish them? Should you consider them? Are evidence, if they're evidence of anything, only as to Mr. Robinson and not as to the accused. So 37, Pritchett only, 39, Robinson only. Now, Ms. Mignot, these videos have been extensively litigated. You have filed written objections and you've made many objections, some of which were enacted. In fact, ladies and gentlemen, I should tell you one of the two videos may end up seeming a little choppy because there are parts of it that I ordered redacted. That is not the state keeping anything from you. It is Ms. Mignot being an effective advocate for Mr. Robinson and me deciding that's not relevant to what you all are working through. But there are still the two videos. Ms. Mignot, beyond the objections you've made and argued and preserved, anything additional as to States 39?
Nothing additional, Your Honor.
Okay, they are all renewed and preserved. And turning to the accused, this evidence is not to be used in any way against you, should the jury consider it at all. Do you have any objections to the admission of States 39?
None other than it still may be prejudiced.
Okay, and that's been argued before by someone on your behalf. I will allow, and so you've preserved it and renewed it. 39 is admitted.
Now, to clarify, 39 is separate from evidence that will be contained, some of the evidence already admitted, correct? It's not, it's only the music videos that instruction applies to.
Correct. That's why I said 39.
All right, let's get Miller.
Okay, so we have to turn the music down here. But luckily, we've got our own music that we can play when they do that. Are we just going to start with a song? Because I need some warning here, guys.
In preparation for this, what sort of statistics and facts do you review?
I review several things, whether it be updated news articles, current gang trends. I look at past gang trends. I look at past statistics. One of the statistics that I review is a 2015 study conducted by the FBI. In that study was a threat assessment. In that assessment, they indicated there was over 1.4 million active gang members across the nation, as well as over 30,000 gangs, and those are gang subsets throughout the nation. As part of that statistic, they advise that upwards to 90% of all violent crime can be attributed to gang members. Now, there's a difference between something that is gang motivated or gang related. This is just merely stating that something is attributed to being connected to gang members themselves.
And are you going to review the actual facts of this particular case in preparations for your testimony?
Yes.
Okay. Now, is it your job as the gang investigator reviewing this? Are you involved in the primary investigation as to the underlying charges?
Occasionally I am, but on this particular case, no.
So you were only investigating the gang aspect?
That is correct.
Okay. What is a criminal street gang?
So a criminal street gang is a group of 3 or more individuals, whether formal or informal, who engage in criminal street gang activity. This criminal street gang activity itself is specific crimes outlined by the code section. They're chargeable offenses, so predicate offenses. But what a criminal street gang is going to be a gang of 3 or more individuals, formal or informal, so at least 3 individuals connected to this organization. They're going to have a common name, sign, symbol. They don't have to have them all, but they have to have something that identifies themselves as what they're portraying. And then the last aspect is the criminal activity. So as an example, fraternities, sororities, different organizations, it's a group of 3 or more individuals, but they're not committing criminal street gang activity. So that's what separates themselves. Just an example, the Shriners International. That's a nonprofit organization, a fraternal organization that does good things around the community and across the globe, helping children. Criminal street gang, the Bloods, a group of 3 or more, have identifying signs, symbols, stuff like that, but they're committing crimes. So the real difference between them is if a crime is committed by, say, a Shriner, that crime doesn't benefit the Shriners International. It makes Shriners International looks bad. Or on the other side of a criminal street gang, they commit a crime and instills fear, intimidation throughout the community. It makes that gang more powerful, and they benefit from that crime.
What are the benefits from instilling fear in the community and committing a crime in an open way?
So there's could be several different benefits. One of the reasons is to portray that violence to suppress the community. For example, if someone is living in a community and they are oppressed in that area, that gang has control in that area, that community is less likely to cooperate with law enforcement. There's a word that they use is called snitching. So a community is less likely to cooperate with law enforcement or snitch for fear of retaliation. That's one way of how they control themselves or operate themselves within the community. Another way of why something would be public is because that notoriety not only is it for the community, but it's for outside of the community, whether it's rival criminal street gangs. So they, if it is a violent crime, rival criminal street gangs will know not to mess with them because they are also extremely violent. That's how we become, we get rivalries between several different gangs, and we have different gang wars essentially throughout Atlanta.
All right, got a little off topic. I'm gonna try and stick to the presentation. What is criminal street gang activity?
So criminal street gang activity is a list of several different crimes. How I remember it is violent crime, gun offenses, weapons offenses, theft offenses, racketeering offenses, which is a slew of hundreds of different charges, but credit card theft, entering autos, burglaries. But narrowly, it also does human trafficking as well.
All right, what are the elements of a criminal street gang?
So 3 or more individuals. So 3 actual individual members, whether formal or informal,
guys,
they have a common name,
we're
sign,
not a street
symbol,
gang.
something identifying themselves as a group, and they engage in criminal street gang activity. Now, all 3 of these individuals do not have to go and commit the crime at once. That's just the 3 or more individuals is the gang. So the gang has to exist first.
Okay. And when you say engages in criminal activity, are those the violent offenses, the racketeering offenses, human trafficking, weapons offenses? Is that what you just testified to as the criminal gang activity?
Yes. So criminal street gang activity is just like homicide, aggravated assault, shootings, burglaries, armed robberies, those offenses. So they have to commit those type of offenses.
Does writing bad rap music count as an offense?
Briefly touch up, if a gang exists, then of 3 or more people engaging in criminal activity, then was it just your testimony that it's not necessary that all 3 people be present for every gang crime? Is that correct?
That is correct. So the 3 or more individuals, that's just establishing that the gang exists. But one individual could go and commit a crime that benefits the gang, and it could be chargeable under the 1615-4 code section.
All right. All right. What is this document that is displayed on the screen in front of the jury?
So this is a foundational block of how I create a criminal street gang case. If I remove any single point of this triangle, this iron triangle, then I do not have a gang case. So for starters, if you look at the very top, gang. So 3 or more individuals, formal or informal, who engage in criminal street gang activity, have some type of identifying sign. If you remove crime, for example, they have to commit this crime, but if you remove it and I just have gang and then the person identified of who committed this crime, say if I remove crime and I just have person and gang, well, it's not a gang crime because it's not illegal to be in a criminal street gang. So if you're just a gang member who are minding your own business, sitting at home, and you didn't commit any crimes, then I don't have a gang investigation. If I remove the gang aspect and I just have person and crime, then it's just a person who committed a crime. Gang's not connected. But the moment I have all 3, I'm looking for my foundational block of a gang investigation.
I think our gang sign is going to be the face you make when you eat a really sour pickle.
All right. What do you look to establish a criminal street gang?
So many different gangs have different common names. They'll call themselves, for example, Bloods, Crips, Gangster Disciples, Vice Lords. Specifically here in Atlanta, it could be something creative, something newly formed from a neighborhood, such as Simp Set, or some type of a nickname for a neighborhood that they have. They could have a common color, such as red or blue, purple, black, green. It could also have certain numbers and other identifiers. Some of the more established criminal street gangs that we have, not only across the nation, but here locally in Georgia and in Atlanta, they have several different identifying signs. So different numbers they use, different terminology they use, different colors they use, specific to their criminal street gang.
What are the type of crimes that criminal street gangs commit?
So there's 3 different categories. You have intra, which is going to be your internal gang issues. So think of one gang member violating or disciplining another individual in his gang. You're going to have inter, which is just in broad sense, Bloods versus Crips, so gang on gang. And then you're going to have extra, which is what we see most commonly, which is a criminal street gang versus the general public, someone who's not affiliated with a criminal street gang.
How do gangs get members?
So several different ways, but most typically they target youth or juveniles. So school, the communities, also in Department of Corrections, Fulton County Jail, any other jail across the nation. There's several different ways that individuals can join a criminal street gang.
please tell the jury the different ways to join a criminal street gang?
So the three ways, one could be an individual is jumped in or beat in. So this varies from set to set across the state, across the nation. It could be 31 seconds for one gang. It could be individuals of what they call a 3-on-1, which is 3 individuals jumping on one person. It could be a 5-on-1, 5 individuals jumping on one person. It could be a 1-on-1. It really depends from the set to set, territory, location. A lot of things different matter with this. The time allowed also can vary. Someone who is blessed in is typically such as a family member, like that individual has a high-ranking family member or a brother or sister, uncle, dad, mom, and they kind of just get brought into the gang. They don't have to get beat in or anything like that. Another form of being beat or being blessed in would be if you are committing crimes that benefit that gang. So not all gang members are, let's say, armed robbers, for example, or murderers. Some of them are really good at white-collar crime. So if that is your skill set and you would benefit a certain gang, you may just be blessed in to the organization to help them make money. The last form would be sexed in. That's more commonly for females. However, not all females are sexed in. Some are beat in or blessed in, just like the males. But a sexed in would just be gang members initiating the female by having sex with her.
What is the difference, respect? How does respect differ in the context of a criminal street gang versus the civilian idea or definition of respect?
So respect is everything, and when it comes to criminal street gangs, and I look at it this way: if an individual who is a gang member loses respect, whether it's from a rival gang or the community or within his own organization, that could bring the reputation of his organization, his criminal street gang, down. So in order to increase respect within his organization or into the community, that individual is typically typically have to do something called putting in work, which is committing criminal street gang activity. So committing crimes, violent crimes. You can become more, your notoriety can grow from these violent crimes, not only within your criminal street gang, but for rival criminal street gangs or in your community. You could be feared. And that fear is what protects and grows with these criminal street gangs. Whereas respect as a civilian, if I'm committing crimes, I'm typically not a respectable person, or people don't just respect me at my workplace. If I was to commit a crime, I would be fired. So that's how typical civilian jobs work.
And then amongst the gang community, what is disrespect, both inside the gang and then outside towards other gangs?
So it's very common for gangs to disrespect rival criminal street gangs. Now, any type of perceived disrespect is usually met with extreme violence, whether that disrespect was as minimal as throwing or posting something online of disrespecting a rival criminal street gang member or that criminal street gang. It's usually met with retaliatory shootings, murders, aggravated assaults, robberies, and other disrespect. So it's ongoing, and that's why we have this bottle effect. One criminal street gang disrespects another, that disrespect goes back, and violence erupts back and forth until it's kind of in the situation that we're in right now.
Okay. Young Slime Line specifically. When was it founded?
So it was founded in approximately 2012. It is a formation of several different criminal street gangs. It has traditional criminal street gangs and something that I consider local hybrid criminal street gangs. So some of the formation of it stemmed from Rock Crew, which was raised on Cleveland. It eventually formed into YSL, also known as Young Slime Life, in the Cleveland Avenue corridor of South Atlanta. They do have territory across Metro Atlanta to include Jonesboro Road up to some locations around Smith Street and Irish Street. Some locations on different blocks on Cleveland Avenue as well. They have several different identifying signs and symbols. The leadership has gained notoriety throughout music and crimes throughout the state.
You said specifically Smith Street and Iris Street. Is that in the Pittsburgh community?
It is.
In the city of Atlanta?
It is.
Okay. And then particularly, I'd like to direct your attention to the 1100 block of Iris Street.
Okay.
What is the significance of, or influence or significance of YSL as it pertains to the 1100 block of Iris Street?
So, like I said, they have different territory across Atlanta. Some is on Cleveland Avenue, some is on, one location is on Irish Street. That specific location on Irish Street, they have been known to sell narcotics, and there has been trap houses located with an allied criminal street gang of YSL known as Duct Tape that operates out of Smith Street specifically.
So is the YSL, the area, is that primarily Irish Street then? In that community?
In the Pittsburgh community, yes. And some parts of McDaniel as well, which is like one street over.
Going to breeze through this slide, but is this just depicting the original area where it was first founded?
Yes. And you can see Cleveland Avenue, the Browns Mill, Mount Zion Road area. There's different apartment complexes in that area. It's controlled by Young Slime Life.
What is a hybrid gang?
So a hybrid gang is, so first off, let me explain what a traditional gang is. So a traditional gang is something like Bloods, Crips, Gangster Disciples that has the current rank structure. They have rules, orders, books, Bibles. It can be traced back to the 60s. A local or neighborhood gang is something that has takes on different identifying signs. They use common names and different terminology to identify themselves. Maybe it hasn't been as established. And what we have seen is, especially specifically in Atlanta, and we see the formation of traditional gangs such as Sex, Money, Murder, 9 Trey, even Rolling 60s, combining with some of these local criminal street gangs and forming something new, specifically like YSL, where you have Sex, Money, Murder, 9 Trey, 5'9" Brims, Neighborhood Rolling 60s, all creating one gang to essentially control an area, to make money, and to commit crimes and gain notoriety for the criminal street gang. Now, a lot of people think, oh, well, like this is weird because they've seen on movies like in the 90s or something like that of like Bloods versus Crips. There's this huge rivalry, but the reality is like that is not existing. While that may be common in specific areas, that's not what is happening here in Atlanta. Now, there are some rivalries of Bloods versus Crips. There are some rivalries of internally with different Crip members or different Blood members of the same organization. But the reality is most of these gangs are forming together, creating their own individual hybrid gang, and then controlling a territory or multiple territories across the city.
What are some of the terminologies used by Young Slime Life?
So there's several different terms that they use. One of them is SLAT for SLATT for slime love all the time. For one of the symbols that they use the color green in snakes, so in slime. So if you see anything with that type of terminology, it could be an identifying sign for YSL. Some of their other acronyms they use is ESPN, Every Slime Play Nasty. Rob for some of the Blood members of YSL for representing Cleveland Avenue, which is raised on Cleveland. And if other members may say raised on Cleveland for Rock Crew. RG for Rudy Gang, which is one of the members that passed away as a juvenile. He was killed. SOS, Slime on Sights. These are just some of the terminologies that they utilize.
What would slime on site mean?
To kill someone on site or do extreme violence to someone.
What are some of the common identifiers you see associated with the young slime life gang?
So the common identifying sign is the color green. So whether that is bandanas, the use of emojis on social media, such as green hearts, snake emojis, little emoji icons of the green throw up. There's several different things, but the color green is very specific to them. Another one of their hands or one of their signs is you can see depicted in this photo is an individual throwing up YSL. So it's
you tap the bottom portion of your monitor. Please circle the YSL symbol.
So right here, you can see that individual is throwing up a Y. The S is with these two fingers, and then you have the L. So that's what YSL will throw up. Some of the other identifying signs that you may see with this criminal street gang is specific to whatever subset they may be. So if I was a sex, money, murder YSL member, I would throw up sex, money, murder. If I was Night Trey, I would throw up this with a YSL. So it varies for each individual person, but YSL as a whole, this is a common identifying sign is YSL. The color green. And if you go to the next slide, I think there's some more images.
You can erase that circle.
Okay. And this is just more depictions. You can see I made an outline of the YSL and a hand sign, so it's just more easily identifiable to see. It can be commonly misidentified as a rival criminal street gang of the Inglewood family, the Nine Deuce, which is also operates in Atlanta. But they throw a very similar hand sign, just a kind of a quarter of an inch. So for an IF would be a rival of YSL, but specifically YSL throws it as a specific, very abundant Y.
What other symbols do you often see them, or motions do you see them make?
So another common hand sign is a wiping the nose aspect. I'll sometimes see these individuals throw up the wipe under the nose and then also throw up YSL. It's not uncommon to see both of them at the same time. That terminology is to wipe someone's nose. So it's to essentially the reference of killing someone, causing serious injury, robbing, shooting an individual. They'll commonly refer to sliming someone out, which is a reference to committing extreme violence to that individual, and that's how they would identify it.
Are there any sort of animals, reptiles associated with YSL?
Yeah, so it's mainly snakes. They really like using snakes, and whether it's music videos, holding snakes, utilizing the snake emojis, they will also commonly use like lizards and other reptiles.
What is tagging?
So tagging is just essentially spray paint from a criminal street gang that identifies a territory owned or operated from that criminal street gang. It's a warning sign to rival gangs, like, hey, this is owned by us. It's also a warning sign to the community of who actually operates in an area.
What sort of common identifiers do you see on social media often associated with YSL?
So there's several, but green heart emojis, green snake emojis. You can see several different postings, just kind of various descriptions of slime or slat for slime love all the time. There's a reference of blat for blood love all the time. The reference of slime, the reference of YSL. These are some of the common identifying signs that I see with investigating this criminal street gang.
And what is the significance that the music industry plays in the criminal street gang activity and criminal street gangs in general in Atlanta and across the country?
So it's very common for some of these criminal street gangs that may have a record label to be discussing types of violent crimes that this criminal street gang commits and is committed by the organization. It also can be used as a recruiting tool in some situations to the youth in our neighborhoods and our communities. But oftentimes it's they're able to show disrespect to rival criminal street gangs or rival members. They're able to brag and boister their criminal street gang of how it's better by showing off money. They're also able to display guns, whether props or real, because they often will put disclaimers on their videos that say these are prop guns, but it's still portraying the same imagery of, hey, we have guns, we're armed, and we're willing to commit violence to a rival criminal street gang.
Have you seen a theme of real guns being used in videos with a message saying this is prop guns?
I have several times.
Why do you think that is? What are they trying to avoid?
They're trying to avoid incriminating themselves, typically, if that individual may be a convicted felon or something like that, and he's in a music video with his criminal street gang holding a gun. He would rather it's a prop, so he's not incriminating himself.
And I think this would be a good point to share music videos that you've identified as being relevant. I am going to play each one only once, and in between, I'm going to ask you some questions of how they're connected to criminal street gang activity.
Okay.
And a reminder, ladies and gentlemen, these two videos are being admitted for your consideration, if you consider them in any way, as to defendant Robinson only.
Here we go. You ready? I'm all queued up. I know you can get away with a few seconds. I've got to cut as much out of it. I've had a claim come in under 7 seconds.
So you're not going to be able to see it in front of your screen, Investigator Miller. You'll have to turn. But this is the first video you identified. It shows that it's Slim Santana, Ola Runt, and YSL Benji.
Those are fine curls.
Is it common for the artists in these videos to have or call out other prominent members of the gang to be part of their actual music video shoots and promotion of the gang?
Yeah, so it's very common. So if one criminal street gang has an alliance with another criminal street gang, they would even invite them out to this, so to be part of this, to show others who they're aligned with and who they're not. Now, criminal street gang active rivalries and alliances, they change very, very commonly here in Atlanta. So this is just, one example of an alliance.
Okay, here we go.
Wake up in the morning wearing headphones. I'm running court into your brain like it's an end zone. My money's green like the pickles and you want some. Don't interrupt cause I don't want your lame objection. From leg t-shirts to murder, I think I've seen it all. From picking juries to when the gavel falls. The judge takes the bench and the bailiff yells, all rise and pay respect to the one and only go to true crime. Imitators, they try but they just can't achieve. And when they fail they be like, ow, I stepped on a beat. Take the stand and the jury chooses not to believe, because there will never be another creator like me. Big deal in one corner and the count in another. We've got the judge reading chat while we talk to the lawyers. All our clips go viral, they're the good not to share. Came in late, check the thumbnails, you'll find it all there. They say I'm addicted to rhyme, but it's more than just time. And the mic is hot, the gavel drops, and I'll be talking about crime. And don't you worry about the sound, cause I'm keeping it real, just like a pickle jar, but I'm one big deal. They say I'm addicted to rhyme, but it's more than just time. And the mic is hot, the gavel drops, and I'll be talking about crime. And don't you worry about the sound, cause I'm keeping it real, just like a pickle jar, but I'm one big deal.
I'm not sure if we have time to play the other one as well. Oh, let's see, which one is this one? Nope, that's it. Nope. Come on, come on, come on.
Wake up in the morning wearing headphones. I'm running court into your brain like it's an end zone. My money's green like the pickles and you want some. Don't interrupt cause I don't want your lame objection. From leg t-shirt to murder, I think I've seen it all. From picking juries to when the gavel falls, the judge takes the bench and the bailiff yells, all rise and pay respect to the one and only know the true crime. Imitators, they try what they just can't achieve, and when they fail they be like how I stepped on a beat. They take the stand and the jury chooses not to believe, because there will never be another creator like me. Big deal in one corner and the count in another. We got the judge reading chat while we talk to the lawyers. All our clips go viral, they're too good not to share. Came in late, check the thumbnail cause you'll find it all there. They say I'm addicted to rhyme, but it's more than just time. And the mic is hot, the gavel drops, and I'll be talking about crime. And don't you worry about the sound, because I'm keeping it real, just like the pickle jar, but I'm one big deal.
1100 block.
And is it common for gang members to use the block numbers associated with their name and referring to themselves and or others?
Yes, it is very common for them to create music videos or social media postings in their territory that they control.
Okay. And I heard a couple terms that I want to ask you about. There was a reference to wiping someone's stain. What is stain, and what does that mean in context of saying wiping someone's stain?
So stain is like, it is a rank or status, respectability, has like multiple different meanings within a criminal street gang. So the only way to increase your stain would be to increase your status of that criminal street gang. So for example, if I was a newly formed member of within a criminal street gang, I just got beat in and I hadn't committed any crimes for the gang, I would be known as someone that doesn't have any stain yet. Whereas someone who is a known shooter or a known robber or known for killing or disrespecting rivals, they would have more stain within the organization.
What does it mean to wipe someone's stain? If you wipe someone's stain, they can't get it back. What does that mean?
So wiping it would be to kill that individual, wiping them off, like it would be that context.
We have one more music video.
Oh man. Okay, we've got to turn this one off.
And this is this the date that you were able to retrieve this video? Play nasty.
Yes, it would be.
And where did you first come across this video, Play Nasty?
It would have been publicly broadcasted on YouTube.
And did you ever see it inside of? Did you review Tyrone Robinson's phone?
Yes, I did.
Did you see this video actually stored in his phone as well?
I did.
Okay, we don't have anything to play over the top of this one because I still haven't released my second album. I guess a second single would be what it was, but. So, let's see. Do we have any music we can play? Just like, oh, I've got to send it. Here we go. Looks like just went ahead with their sound instead. Do they have an armor on the set when they film these? Asking for a friend. Go.
Now, what does the term false flag mean?
So false flagging would be if an individual was to false represent that he was part of an organization that he wasn't part of. It's very rare, and if it does happen, or
it's like stolen valor, happen, but in a gang
and that
setting.
Individual would be met with a real individual of that gang, and they found, or they knew that individual wasn't part, they would be met with some type of extreme violence, whether it's like beat up or robbed or shot or killed. But something would happen to that individual if they were caught false flagging.
Okay. Now, based off of those two music videos, do you have a determination of membership of the gang YSL of Tyrone Robinson in your expert opinion?
Yeah, so he's in the music videos. There's several different identifying signs that we saw in both videos. It was hand signs by individuals such as YSL, the different organizations that make the different national criminal street gangs that make up YSL, such as Sex Money Murder hand signs, Nitre, the green bandanas, individuals wearing chains that say YSL, some of the individuals in the music videos being charged with other YSL crimes and connected to other crimes of YSL. The collectively and totality of all these identifiers, yes, I confidently say that he is a member of YSL or Young Slime Life.
Okay. Now, these images that are included appear to be screenshots or images taken during the shooting of that music video.
That is correct.
And did you come across these on Tyrone Robinson's phone?
I did.
Now, especially considering that this was filmed on Ira Street in the city of Atlanta, what would be the ramification in this city of false flagging or stating your membership without being a member?
You would be met with extreme violence if you were false flagging in their territory. You would not be invited to be a part of anything that they're doing.
Now, I understand that these are music videos. Are the music videos in and of themselves illegal?
No.
Okay. How does the crimes committed by these members, how does it promote, or does it promote the gang when they are sung about in these music videos?
It does. So, for example, in the first music video, they were talking about that they gave threats to rival gangs, like "Don't mess with us." They also talked about selling za, which is marijuana. So they're talking about drug sales. In the second music video, they're talking about specifically how they will get individuals who are with them to pistol whip you and to rob you and to injure you with firearms. So that is boistering that they are a violent criminal street gang and willing to do those offenses, and that they do those offenses.
Now, I understand the dynamics here and the way, but all music, in particular rap, not all rap music is considered gang associated, correct?
No, there's all kinds of rap that is not gang related. Some is, some isn't. For example, some's making millions, some isn't.
That's ours.
It just kind of depends. No, there's all types of music though.
And I want to also touch on another dynamic too. Do gangs themselves tend to be segregated based on race, whether it's white or black?
Yeah, so it can. So it's not all gangs, but some gangs are racially motivated, such as any type of white nationalist type criminal street gang is primarily white men. KKK is typically, the Ku Klux Klan is typically white people. Gangster Disciples, which is a criminal street gang, is actually a mixture of both white and African Americans. Hispanic gangs are typically, for example, like Serenos are typically Hispanic or Latinos, or some white people. Nine Trey, Sex, Money, Murder, most Crips, predominantly African American, but occasionally there are some white members. Same Pyru can be predominantly African American, but there are some white members, some Hispanic members as well. But it really depends on the actual criminal street gang itself.
Now, what's the importance of fashion or clothing and colors inside of the criminal street gang?
So, it can be important to display or flag your colors and represent your criminal street gang through social media. So specifically though, it's not as boisterous as TV or movies makes it anymore. It can be, but it's typically not. Like, you don't typically have an individual who is wearing red shirt, red hat, red shoes, red pants, with a red bandana, walking down the sidewalk saying, "This is my hood." Typically is a little bit more discreet, because that would attract a lot of heat by law enforcement if we saw that. That's like kind of a red flag goes off, so to speak. So individuals they'll still flag, but they will commonly reserve that for social media postings, for example. Occasionally the younger members can be caught with flags, like whether it's tied on their right side or left side, or in their pockets, in their front pockets, back pockets, tied through their belt loops, or tied on a firearm, can also be common. But it's not necessarily, you have to, wear green head to toe to be considered a member. Some members could, you can wear nothing that's green, but still represent your criminal street gang online or in the community by displaying the hand sides, tattoos. So that's why there's so many different identifying signs for these criminal street gangs.
And are these more, these photos that are here, are these more photos and screenshots that you obtained through Tyron Robinson's site?
That is correct.
So what is the screenshot in the middle, Slim Santana? Who would that be? Would that be the artist we just saw?
That is.
Okay. And the individuals in that, do you notice any signs and identifiers of YSL?
I do. So right here, that individual is throwing up a YSL while holding a green bandana. Robinson right here is throwing up YSL while wearing a green bandana. This individual in the middle, he's throwing up a very common blood hand sign. It's this for blood love. This individual is Slim Santana. He's throwing up a double pistol, which is paying homage to Sex Money murder founder Peter Rolak, who went by the nickname Pistol Pete, just another criminal street gang that is part of YSL. And then you have the accused right here wearing holding a green bandana. Some of the other captions in this as well in this posting, I can't really see it from mine, but it says, meet with the rap shit, 1100 snake pit. We're gonna take some. I had to tell my partner Jill because he was gonna whack some with a tornado emoji. So that tornado emoji is reference to like spinning or like to spin the block. So shoot or rob or steal. The snake pit reference is a reference to they have several individuals and members in the 1100 block of IRA. Since they will reference themselves as snakes, they're referencing that territory as a snake pit.
In that last photo, keep moving, but that last photo, can you please, that screenshot, who appears to have posted that screenshot?
So the Instagram vanity name is Rick Rare.
I think we've covered this. Actually, I want to get back one thing. Only on the far right picture, what does happy Slat Day? What does that mean?
So it could be multiple different meanings. It could be that individual's birthday. It could be different criminal street gangs have their own hood day. So it's like the birthday of the gang. So YSL does have their own hood day. They have a Cleveland Avenue Day that's hosted on Cleveland Avenue. That they have individuals that have cookouts, music, people usually drinking, maybe a little bit of marijuana use. But it's an event-based community event that they host.
Okay. And to be based on what your testimony earlier is, if all these gang members were associated, in fact, hanging out, just drinking beers, having a good time, so long as they're not committing any crimes, there's nothing illegal about that, correct?
That is correct.
Now, this particular case, are you aware of the general facts of the case, the home invasion at Wiley Street?
Yes, I am.
Okay. Now, what is it that connects, the person being Tyron Robinson to the gang and to the crime itself?
So we saw. Could you repeat your question one more time? Because there's like three parts.
Sorry, I should have. All right. Let me start with this. When it comes to criminal street gang activity, what is a nexus?
So a nexus is it's a word we don't typically use, but it is simply a connection. So how does that connection or that activity benefit the criminal street gang? And if something benefits the individual member, it in turn benefits the criminal street gang. So a good example of a nexus would be individuals committing a crime in public or with another individual that would increase both individual status because they had a witness with their gang essentially witnessed them commit a crime. So they would be able to tell other gang members of what they're capable of and what kind of crimes that they do, which in turn would increase the status of the gang because they commit violence.
Okay. Do all nexus, in a sense, do they all have to be a public commission of a crime?
No, I mean, it can be as simple as making money from drug sales. It can be as simple as stealing guns or stealing an item. It can be as simple as killing a rival, criminal street gang member. That would benefit the gang. It could be multiple different aspects of how a nexus could benefit a criminal street gang.
And when you're dealing with nexus and looking at how it benefits a particular street gang, do you tend to, do you ever look to see if whether the proceeds of a crime are split between the members of the gang?
Yeah, so sometimes there's evidence of, or we get through, different interviews that I've done throughout several different investigations. Funds or proceeds from a crime can be distributed in a multitude of different ways. But yes, when the profit is shared, it's usually shared by those who commit it, and whether who else benefits from it from that criminal street gang, whether an individual member kind of gave them a heads up or kind of orchestrated this crime, would that individual benefit from proceeds, or if that individual kind of paid them to go handle something. It really depends it's totality based.
Wow. All right. We saw those pictures earlier of when it comes to defendant Pritchett. This one here, what do you see that indicates any reference to YSL or that specific cell?
So
there's just a delay. It's really bad. Can you see it?
It's medium bad.
I was looking at 3 different screens with different.
Yeah.
This one's.
So there's several different identifiers that I see. One is the accused depicted in a photo with his Instagram handle, but he's standing with individuals who are throwing common identifying signs. One individual's throwing up a double pistol. One individual's throwing up a big B for Bloods. This individual, his moniker is YSL Benji. So he's actually using the acronym for the criminal street gang YSL while throwing up different hand signs. Then the posting itself is reference to 1100 block with a green heart emoji. And although this geotag says Pittsburgh, Pennsylvania, this appears to be the same house that was shot off of Irish Street in the Pittsburgh community of Atlanta.
They got the location tag wrong.
Has your string changed?
It has.
So same question with this picture. Any one, where is this? What's the poster of this picture?
Yeah, so this is a posting from Rick Rare. You see an individual throwing up YSL for Young Slime Life. The utilization of a green bandana, which is a color used by YSL. I see the actual posting states, can't really see because of the zoom aspect, but it tags 2 individuals, a Young Bands, which is a rapper, a YSL rapper, and then Rick Rare. And then they're also posing in a Rolls Royce, which is, a high dollar item.
The caption, can you read it from the here?
Okay. This is, I got you. I moved my face. The caption states, Red Dead was hard. So I'm assuming they saw a movie. There's a snake emoji. There's a acronym of SLAT. And then their Instagram vanity names.
So, based off of what you've seen in your investigation into the gang aspect of this crime, would you consider Mr. Max Pritchett, or also known as Rick Rare, to be a member or an associate of the criminal street gang YSL?
Absolutely. with the several different postings using acronyms commonly used by them, holding the green bandanas, communication with them, posing in their territory. Absolutely, I would say he's a member of Young Slime Life, YSL.
And again, in the city of Atlanta, as it goes to Max Pritchett specifically, what would be the fallout of holding yourself or false flagging as a member of YSL if you were not?
Objection on, ask and answer. More than once.
Indeed. Next question. It'd be only once, but still asked and answered.
Okay. Now, I'm showing you what's been admitted is criminal street. I mean, what's been admitted is State's Exhibit 16.
Apparently, those are not highlighter yellow.
What about the cost and color of clothing? How does that come into effect or play a part in criminal street business?
So it's very common for criminal street gang members to pose with high dollar items, whether it's high profile shoes or like Balenciagas or Versace shoes, and posing and kind of flexing like how much money they have or how much money the gang is making. So that's very common.
Okay. And is it common for the members of those gangs to buy those high dollar clothing items in the colors associated with their gang?
It can be. It can be. So, for example, like what's depicted in this photo is looks like a very lime green, slime green color that they utilize. So it wouldn't be uncommon for a YSL member to purposefully kind of flaunt that color.
And then this last picture, and give this picture of a warrant.
Aggravated assault with intent to rob.
That picture, is that another picture that you uncovered inside of Tyrone Robinson's phone?
It was.
Okay. And what about the other two pictures pertaining to the two defendants? Were those both recovered from Tyrone Robinson's phone?
That is true.
So all right, so as it pertains to your PowerPoint, I don't have any more questions. I just want to talk about the Instagram and how you utilize it in determining specifically when it comes to differentiating between vanity name and username. And give me 1 second. I'm going to go through what's been State's Exhibit 29. What's the difference between a vanity name and an account name?
So a vanity name is your username. An account name would be, for example, like your common name, John Smith. Your vanity name has to be a unique identifying sign different from any other vanity name on Instagram. There's either one can be changed, but they are different.
I'm popping up now. All right, so I'm currently inside what's been identified as State's Exhibit 29.
Okay.
Okay. So this is the Instagram dump of Tyrone Robinson. So I want to talk about a few things too. So I see that there are a couple, the first three, one's an affidavit, one's a PDF, and one's a zip file, or the last three. Are those, when you get the records, is that what you see originally?
Yes. So essentially the PDF files is time, date stamp of all the integrated videos, pictures, and so forth in this file. You'll see a zip folder, and it will have different content such as audio, if someone sent like an audio voice message or something of that nature, such as a call. If there is a video posting or a story posting or any other type of social media posting, it'll be in that zip file, whether it's video, picture, or audio.
Okay. And so the zip file, as it's zipped, is that going to contain the date that it is turned over to you, or Instagram turns over the records?
That's typically whenever it's whenever it was pulled. So whatever custodian, whether from Facebook, whenever they pull that record, it'll typically be in that format. However, if you go through the business records aspect of it, it'll have a date time stamp of when the items were essentially posted, uploaded, shared, transferred, whatever the action may have been through those records.
Next question is going to be, can you even access the linked media and the digital media until you unzip that original file provided by Instagram?
Can't.
Well, so it varies because each time it can be unlocked from a different, or you might get a different format. You might not even get a zip file. So it really kind of depends on the volume of items you receive. But if you were to get a zip file, no, you wouldn't be able to look at it until you went into the format.
And then the date of the linked digital media, is that going to then reflect the updated file of the date that it was unzipped as to the file name, not the media itself?
Yeah, it could, as long as it's, done properly. Yeah.
Then now, after stop sharing, we'll show you this last. All right.
Count the pages on this one. What were they? 49,000 is what I saw.
The account name.
43,000.
Account name right here. What does that say?
So the account number says 1100 baby slat.
The account name, okay. And then the registered email, what does that say?
It says Robinson Tyrone 999@gmail.com.
Okay. And then the vanity name.
The vanity name is _the goat 1100.
Okay. Now, are the account name and the vanity name going to be displayed simultaneously on the front of your profile?
It can. It depends on the user's account and how they have it set up. So some people don't even have anything under their account name. They could just have a vanity name. Some individuals could have it matching. So it could say, John Smith, 1100, John Smith, 1100. It could say 1100 baby slat or the goat 1100. It can be changed whenever the individual wants to change it. There's a specific record number that is associated with that vanity name and that Instagram records that never changes. So as long as that account was created, every content, no matter how many times someone changes a vanity name or an account name, the records can be still figured out.
Okay. And is that number that never changes the target number?
Yes, it is.
In the vanity name, is that generally what's used with the @ when you are tagging somebody?
Yes.
Okay.
And is most commonly referred to as a username. Instagram and Facebook, they call it a vanity name. So I just call it a vanity name.
This is their big finish. The state's about to rest.
It is a vanity name.
They need a big punch in the end.
At some point, they'll both be displayed on the front of the profile.
Yes.
No further questions for this witness, Your Honor.
All right. Ms. Mignot, you have more than 5 questions for this witness?
Is that a trick question, Judge? Yes.
Okay, I'm gonna hold you to that then. We're gonna break for lunch, ladies and gentlemen. I think it'll make the cross-examinations flow a little more smoothly because the lawyers can work on them during lunch rather than jumping to.
Lawyers
and we'll just ask Investigator Miller to return after the lunch break and not talk about his testimony during that lunch break. It is about 12:40, somewhere about that. 1:30, too quick to have you be back? Seeing no one say no, great. Let's try to be back at 1:30 to continue with Investigator Miller's testimony.
So we get a half-hour lunch.
We'll pick it up there. Any logistical questions? Enjoy your lunch break. No outside research. Don't talk about the case.
All right, jury's headed out. We're going to take a lunch break as well. We'll be back. We only get half an hour, though, so I'm not sure what you're going to eat. Hopefully, you're already making your sandwich, if that's what you have on the plan. I don't have half an hour is not enough time to put up the second layer of coat, the second coat of paint in the bathroom, so I'm going to have to do that tonight. But if they'd gone an hour break, I would have done it.
Mr. Hiles, this is still your final witness.
Yes.
Ms. Mignot, you've had the weekend plus a witness and a half to continue thinking about this. At this point, are you planning on calling any witnesses other than whatever Mr. Robinson decides, which we don't need to discuss yet, about testifying?
No, Your Honor.
Okay. And Mr. Robinson, not yet, but once the state rests, we'll be having that conversation I discussed on Friday about whether you choose to testify. Okay? Great. Mr. Pritchett, same question. Do you plan on calling any witnesses other than yourself? And if so, will they be here this afternoon? Because it sounds like the case may be in your lap mid-afternoon.
I do, but the earliest I could get them to come here would be tomorrow.
Okay, well, we'll have to talk about that during the break after the state rests. And see whether we're going to wait till tomorrow or not. Ms. Riley is here and you're here. So should you have a good faith basis to call her, that can happen. And should you choose to testify, that could always happen today as well. I don't know that we'll take the afternoon off for other witnesses, but we'll talk about that more when we are working through the break that will naturally occur when the state rests. All right? All right, that's it. Let's be back, all of us, a little before 1:30, so we're ready for the jurors. Thank you. I'll mute the microphone in here. Folks want to stay.
Thank you.
Was the case okay for you, Your Honor?
It's probably not a great question to ask in this case.
What was that? Was the pace okay for you? Wow. Okay. Judge says no. Too soon. It's too soon. All right. With that, we are on break. We're ready for lunch, and it's going to be great. We're no news from the Kelly trial yet. Hopefully that'll come this afternoon after lunch. We get a half-hour lunch. We've already opened up the thumbnail for the break because we only get half an hour. So I'm coming back. Well, a little over half an hour. But we'll be back here live before 1:30 where they start. It's 12:42 right now, so it's going to happen really quick. All right, that's everything. We just get to play the music, take a break. I'll stage the remodel project, like with the bucket of paint and the new roller and everything ready to go. So as soon as we end tonight, I'm going to paint. If I start on the bottom and then finish the top, the bottom will be dry so I can lay down the flooring tonight. I might even seat the toilet tonight. Maybe start with the base of the shower. Maybe plumb the sink. That's a pedestal. That's pretty easy. We're moving. We're moving. I'm kind of organized. Hey, this is the best I can do right here. The best we can do. All right, we're going to go ahead and take a lunch. It's a little bit slow, but the state is resting. This was their last witness, and it's going to go quick from here on out, I think. It won't go smoothly, because I don't think the accused is going to be able to do what he wants to do with his witnesses, mostly because he's going to find out that leading is very easy to do and hard to get around. And when it's your own witness you call, you can't lead. So it's going to be a challenge for him, I think, but we'll see how this goes. Tonight, when you go home, please hug the people you love. Smile at someone to make their day just a little bit better, and please stay safe, too. We'll go live again in about half an hour. You guys enjoy your lunch. We'll see you back around here. Bye.
Is that correct?
Because he's the guy.
When are we going to break for lunch, Judge?